Lordship, for hearing item number 1, Lordship, I was required to take certain instructions, Lordship. Those have not come. Lordship, I am praying for 2 weeks' time if Lordship will permit. I have taken the consent of Mr. Nayak, Lordship.
Mr. Chaudhary, Leonard, Deputy SGA, Mr. Chaudhary submits that he has not received instructions in terms of the order dated so and so. He also states that Mr. UK Nayak, Senior Counsel, representing the respondent, has been informed and he has given consent for adjournment of the matter, for deferment of the matter. Re-notify on 28 September as 28 will go in October. 5th October as Ms. Jati, keep it plan. How many cases we are listening for hearing? Too many now. They're becoming 10, 15.
Yes, item number 23, Miller. Lordship wanted to ask to file an additional affidavit to bring on record an original application. Well, the appellant is in bereavement, Miller. Lordship will give us 1 week time, Miller. 23.
And thus some more time.
23.
File some affidavit.
Additional affidavit.
File an additional affidavit on his behalf. List up 4 weeks.
File a plus.
Wait, please, your Lordship. Mother, item number 17, Miller.
17.
Miller.
Yes, what
We have to file the impediment petition, Miller. We have to file an impediment petition. Impediment petition. I would pay for time on different count. It would be unfair on my part if I do not give the respondent alleged contender some more time. It may come up in 2 months' time, Miller. That would be
in all probability, the contemners, that the order under contempt is in the process of being complied with.
no, I'm not on that. I am to issue a representation or notice to the person we have issued. He must get the due time.
He has been, his client would be better advised to seek deferment of this contempt petition by some period so that some new facts can be brought on record. List after 8 weeks as well.
I'm so grateful, Miller. Obliged.
May I please, Lordship? Lordship, I beg to mention item number 15 in the daily list today.
Yes, please.
It was for filing of a compliance report and taking steps against encroachers, Lordship. I have taken steps, but the compliance report needs to be filed, Lordship.
And counsel, your good name is D. Saraf,
Lordship.
appearing for
Respondent number 3, Lordship.
for number 3 contemptor, placed for and is granted 4 weeks time to bring on record to file the compliance report
Lordship.
on record. List up 4 weeks.
Lordship,
Yes, please. Yes.
I am for the private respondents, Lordship.
In which matter, madam?
Item 15. Here in one course list is written item 15. Another one is written item 16. State of Nagaland versus Kyoto, Semen, another.
And that has not been mentioned, madam. We have still taken up the item number 15 only. You are in item number 16, we suppose. 16 has not been mentioned. What do you want in 16?
16, I am ready for taking up the matter, Lordship.
What are you praying for?
Item number 16. If my
Yes,
learned Advocate General is mentioning on
yes,
that.
he is there. Mr. Balagopal is there. What do you want to mention? Mr. Balagopal, we couldn't get what Learned Counsel is trying to convey.
I think she has misunderstood that I want to mention something.
Yeah.
I in fact don't have to mention anything. I will wait for my turn.
Let the matter be called out, madam.
In the term, right.
Yeah.
Lordship.
Wait, please, your lordships. Lordships, in item number 45, we have filed a rejoined affidavit on behalf of the state.
You
of
have
Reservation.
filed
Yes, your lordship. That may kindly be called for.
today itself,
Yes, your lordship.
Mangali ji.
You please.
Oh.
Daily list for orders, item 16.
Then I'm sorry, Milord. Urgent writ appeal, Milord, tomorrow, if possible, Milord.
We already granted you permission. No,
Permission in the administrative side,
all
Milord.
right, it listed tomorrow.
Nice. Highly obliged.
Item number 16, all right. Mr. Balagopal, steps have not been taken for respondent number 2.
Oh, I'm
in
sorry.
item number 16.
I'll take immediate step.
You are
I'm sorry.
appearing for which respondent in this matter? Madam,
My lord,
you are representing,
state, my lord, already served copy on
there's
response.
a lawyer on VC. You represent which of the 2 respondents?
1 and 2, lordship.
Both respondents?
Yes, lordship.
All right, MSS Zinomi puts in appearance, and counsel MSZ Zinomi puts in appearance on behalf of both the respondents, right?
Lordship.
All right, the service is complete and steps need not be taken. List for admission on. Mr. Balgopal, when do you want?
Any date is convenient to your lordship, madam.
List for admission on 13th September. Is it all right, madam?
Lordship.
13th.
Can it be
13th.
admission hearing, my lord? I pray.
Very well.
Admission, yes, we are listing it for admission hearing.
13th September is all right, madam.
13th September.
Please, madam. I'm obliged.
Obliged, lordship.
Item number 18.
May it please your lordship. This contempt petition has been prepared against the order. Lordship would be pleased to find the operative.
Against
portion
the
of
order.
page-
Is it
Yes,
an appeal or is it contempt?
contempt, lordship.
So how the contempt can be against an order? All right, let us know what is the matter.
For the lordship page 22, there was a specific direction to the respondent number 5 for relocating the toll gate in question at the modern tool. That was the issue. And after the order of this honorable court was duly communicated, and after a considerable period also, they are sitting over the matter. That is why.
NHI has filed an affidavit that toll plaza will be adjusted within
Yes,
so and so after completion of the corridor has been completed.
yes, lordship. Time,
This was a conditional undertaking.
yes,
What has happened to the corridor? Corridor has been completed or not?
that lordship, they,
Madam, you are in contempt.
yes,
Now, the order under contempt says that the undertaking or affidavit of the NHI that they will shift the toll plaza is subject to a condition that the project will be completed. Now, you make a statement.
they have not done anything, lordship.
What have you said about the project?
They have not done anything thereafter, lordship.
Let's see. You will have to give us information that the project has been completed. It is stalled for certain reasons. That information you will have to give.
Yes, lordship.
So, all right, and counsel for the petitioner, praise for time to place on record additional information through an affidavit regarding the current status of the east-west corridor from Srirampur to Kochugaon. List up 4 weeks.
Obliged.
Item number 19.
Please, your lordship. Mr. A are appearing in the case, lordship. Maybe possible for the time being.
Passed.
Like,
All right. Passed. Next.
Item number 20 and 21.
IA. What is the IA for?
My lord, the IA for delay continuation. There is.
How much is the delay? There,
My lord,
why the other two matters were connected?
Because my lord, the other one is filed on the subsequent development of the first one. My lord, the other application was filed on the subsequent development of the first one, my lord. For interim,
All right. Who are appearing for the respondents? All respondents are represented?
Private respondent.
Private respondents are there. Private respondents means 11 should, all right, issue notice to the respondents. Issue notice, the respondents numbers 1, 2, 3, 4, 6, 7, 8, 9, 10. 9 and 10 are represented. Thus, steps for service upon the remaining respondents be taken in 3 days, whereafter process be issued.
my lord, the interim may be given, my lord. Interim protection may be given.
Your appeal is not even registered as yet. How interim protection is to be given?
But my lord, at any.
Your appeal is not even fit to be late for admission. Without that, we will grant you interim protection. How that is possible? You take, get a service effected quickly.
Yes, my lord.
Steps for service be taken within 3 days, whereafter process be issued. Rule is made returnable in 3 weeks. Hmm? 24 also, 21 also. Or 21 वाला भी इसका भी notice करते हैं. Same order, notice.
Obliged.
Item number 22.
Matter was called out, none present for the petitioner. Yes, lots.
May I please, your lordship?
What is the petition
This is
about?
a case, your lordship, where your lordship, the petitioners belong to your lordship, Jalha community, your lordship, which was originally among one of the community within your lordship, T-tribe communities, your lordship. And they were considered as an OBCs, your lordship. And these persons belong to Barak Valley, your lordship, 3 districts of Karimganj, Hailakandi. And your lordship, if your lordship comes to page 26, your lordship, this is the first notification, your lordship, where they were declared as othermost
OBC.
OBC, your lordship, serial number 83.
83, yes.
Then your lordship, in 1993, your lordship, post Indra's and his husband, your lordship, the central list of OBCs will declare, your lordship, and your lordship will find their name in the serial number 40 of that, your lordship. As extract I have annexed, and the main copy, your lordship, at page 30. And the type is, your lordship, page 27. If your lordship comes to page 29, serial number 40, Jalha, your lordship. Now, your lordship, they were getting the benefits. And in the meantime, what had happened, your lordship, if your lordship comes to page 35, these are the, your lordship, certificates issued in their favor, your lordship. This community, your lordship, although under T-tribe community list, your lordship, they are by religion, they are Mohammedan, your lordship. Now, your lordship, they are receiving that.
Before my senior continues, only one thing I will bring it before your lordship. Page 60 is the imperial order, my lord. It's issued by Social Justice and Empowerment, my lord. They have a standing council. His name is not in the cause list. I think his copy.
We have not even issued notice as yet, sir.
Lords.
So the question of reflecting name of the standing council will come once we issue notice. We may dismiss it in limine. Right? Is it permissible or not? Is it necessary to hear you at the time of admission?
Usually, my lord, here in Guwahati High Court, my lord, this is a practice.
Tell us the provision of the rules, the scheme of the act or the constitution that in a writ petition, it is essential to hear the other side, even for admission. No?
Now, what has happened, your lordship? The notice was issued, your lordship, by the Assam Backward Class Commission, that is at page 56, your lordship, to the president and general secretary of your lordship, two organizations which your lordship represents interest of these Jolhas, your lordship, and asking them to show cause as to why their names should be not be deleted from the list of your lordship communities of T tribes, your lordship. Now, your lordship, then an order was passed, probably your lordship, which was not furnished to these people. Your lordship will kindly come to page 60. That is the
Order.
your lordship. It says, your lordship, in pursuance of recommendation made by Assam Backward Classes Commission in continuation of government notification number so and so 27/11/1975, the governor of Assam is pleased to enlist Jolha community who are inhabitants of Golaghat, Jorhat, Sibsagar, Bishwanath, Tinsukia, Choraideau, Dibrugarh, Lakhimpur, Sonitpur, and Nagaon as separate entity at serial number 32 in the list of OBCs of Assam and remove the community from the list of communities of Tea Garden, ex-Tea Garden tribes Assam under MOBCs.
So what is the illegality in this order?
No, your
What is
lordship,
the unconstitutionality?
lordship, this, so far as this order is concerned, your lordship, this was under challenge and your lordship has already issued notice, your lordship, in a PIL, your lordship. But our concern is this, your lordship, at present petitioners, they have, your lordship, kept it confined to Nagaon, so far as OBC is concerned. The communities belonging to these three districts, your lordship, they are not getting this benefit of OBC right now, your lordship.
They
That's
have
the problem.
confined it to
Golaghat, Jorhat, Sibsagar, Bishwanath, Tinsukia, Choraideau, Dibrugarh, Lakhimpur, Sonitpur, and Nagaon in Brahmaputra Valley, your lordship. Now, as a result of this, your lordship,
Barak Valley people are out
not
of
getting this, your lordship. The concern of this petition, your petitioners is that, your lordship,
So you will continue to remain under the ex-Tea Garden tribes?
no, your lordship,
Why?
your lordship will kindly come to page 61. We are applying, your lordship, for OBC certificates,
But stricto sensu, Mr. Botakur,
lordship.
if the Jola community people who are not residents of these districts,
Lordship.
other than that, they will continue. Their names have not been removed.
That is why, your lordship, but we are not getting the benefit. That's the
Issue
problem,
notice to the respondents.
lordship.
Now the question comes, okay? Service be effected by supplying copies of the writ petition and annexures to the standing council concerned. The Social Welfare Department is a party,
Yes, your social justice, your lordship.
thus the service is permitted. Where is the Social Justice Department? Yes, number one only.
Number one,
Lord, number one. Deep, lordship.
What about this commission? Notice we'll have to go to the commission.
Notices to the man.
Uh,
Notices.
Steps, respondents number so and so are represented by the respondent number 1, 2, 4, 1, 2, 1, 2 and 5, 6, 3 also. Backwards classes commission.
Yes, my lord.
Who will be appearing?
My lord, notices to go.
Yes, 1, 2 and 6 are duly represented. The step you are appearing. All right. 1, 2 and 6 are duly represented. The steps for service on the remaining respondents be taken in 3 days, whereafter thus the service, thus the notice be issued. Rule is made returnable in 3 weeks.
Lordship. Deep.
Item number 24 to item number 24 to 38,
Yes.
along with item 51.
I'm appearing on behalf of respondent number 2, my lord. Affidavit has been sent for vetting. Minimum 10 days time may be given, my lord.
Your and the state stand is little contradictory in this case.
Yes, my lord.
MS Gayan, Learned Standing Council, Union of
CGC,
India,
my lord. CGC. CGC, my lord.
CGC.
Yes, my lord.
Appears in this matter on behalf of the Union of India. She submits that the affidavit to be filed on behalf of the Union of India has been sent for vetting and would be filed within next 10 days. What about these matters, Mr. Nath? 33 to 37, notice has gone or not?
Basically, The private respondents are representable.
When I appear for all well, the stand of the central government has already been vindicated by an RTI given by the textile.
Whatever, let the affidavit come.
Yes,
What is the problem?
Well,
Mr.
they
Das
cannot
appears-
change their stand now.
Mr. Das appears for the private respondents.
In all the cases.
In
all
all
the
the
appeals. All the appeals, thus his name, name of Mr. Das and MS Gayan shall henceforth be reflected in the contest. Who else are there?
Item 51, we have preferred an miscellaneous application, interlocutory application for intervening in the matter, my lord.
On
We are
behalf of,
assailing, we belong to a society, my lords, of tat weavers from Sualkuchi, which is
your
a census
application
town.
is not there. This is your
Application is there,
application.
my lords, item 51.
All right, give a copy to the state and the other side.
Copy has been furnished, copy has been.
Well, a copy has not been given. Basically, they are handloom weavers.
We are handloom weavers, my lord.
State is already taking care of your interest. What is the problem?
I'll
Interim
furnish-
order, Mr. Nath, interim order is passed in which matter? There is an interim order
Yes,
operating in
yes,
which matter?
Yeah.
And first,
In which matter?
Well, in item number, item number 24. 24.
Interim order passed in writ appeal number 284/23 shall remain in currency till next date of listing. List up to 3 weeks.
All right.
What you would issue notice on the IA, my lords, 51, I'll furnish copies.
Notice, interlocutory application number so and so, issue notice to the respondents.
Deeply applied.
Item number 39.
In fact, lordship, in the other case, the interim order was still disposal of the writ appeals. That was
Already there, already, then don't limit it. Let the order go on. Don't write that it will continue till next stage.
I don't know. Yes, passport.
Yes.
My lord, this tender matter, my lord, who had an occasion to examine.
We don't need to wait for Mr. Kumar, easier. Yes.
Now, the matters can be taken up for final disposal, my lord. The other case, second one, my lord, 302, the tenders, the rates were open. And my lord, I don't come in. I don't come in within the
Item number 40,
40.
rate appeal 302.
302.
Rate appeal 302 likhiye isme.
My lord, will only hold that. My lord, I'll have to refer to certain papers there, my lord, just to show
Then
the
well, let it continue.
lordship. Now, my lord, the basic issue before my lord is as to whether non-disclosure by me, by the petition number 1 company of the works which continued in the name of the petition number 2, who is a director in the petition number 1 company, and in his individual capacity, those works were continued. Whether, my lord, that by itself would, my lord, bar me, which they have taken to take me as non-responsible. What had happened here was, my lord, the petition number 1 was a contractor. He was doing works with the petition number with the PWD in the different wings, my lord. Then he constituted this company in 2020. And therein, my lord, he made an undertaking that all my credentials, all the works which I have been doing now will be taken as credential of the petition number 1 company, as I am one of the directors therein. One of the wings, my lord, NH National Highway, PWD National Highway, it, my lord, transferred all the works of the petition number 2 to the petition number 1 company. But the other wings had not done it. Accordingly, when the tenders were issued, my lord, we participated, we disclosed all the works of petition number 2, which were transferred to petition number 1. Then, my lord, the bids were opened. The authorities, bid evaluation community, circulated a letter to the various wings asking whether any other work pending. Border Roads, my lord, comes up and says that these are the works which have not been disclosed in the tender. They take a plea that as I have not disclosed, I have committed a misrepresentation, and basing on that, my bids, I have been declared to be non-responsive and my bid security is to be forfeited. I come up before my lord and then the matter starts. Now, during the pendency of the proceedings, the private respondent appears, madam, and he brings on record one more work of 10/3/23, which LOA was issued to me, which was not disclosed. Admittedly, my lord, it was
appellant number 2, appellant number 1 also.
one. It was in the name of one, my lord.
Company. Yes.
But admittedly, it was not disclosed or not given in this tender. But in the subsequent tenders, even in number 2, my lord, the item number 40, in that tender, those were discussed because the work orders and the notice to proceed with the work came subsequently. This tender was, my lord, said on 11/5. The last date was 11/5/23. The work order came sometime in June. So all the works which were there after that, we
Commencement was a subsequent date.
subsequent date. Now, what happened here was, why this is required? Now, we have more clarity in the matter, my lord. The respondents have filed an affidavit. And in para 13 thereof, they say that immediately on opening of a tender and the financial bids, if you are declared as L1, be that as it may, whether you, my lord, get the LOA or not, you will have to declare that to calculate your bid capacity.
Okay.
Now, if we go by that logic, my lord, in the second case, there are two private respondents there. They have also not disclosed works of similar nature. Here, the private respondent, before the last date of submission of this tender, my lord, was declared L1 in another bid on 10/5. This was on 11/5. That was not disclosed. But no plea, no nothing, no action was taken, madam. That was ignored. I brought that by way of a letter representation before the authorities. In my case, within one day, my lord, they took a decision. But here, nothing has been done till now, madam. But I'll show, my lord, from the affidavit that they say, even if I'm declared as L1, that has to be the logic. The logic behind that is, my lord, the bid capacity, what they try to understand is that whether I have the requisite financial resources
to do the work.
To the work. And for that, my lord, they say that last 5 years, whatever I have received and whatever work is there, which will be done concurrently with the work under question, my lord, whether I have the resources to do that. Now, in this tender, they had examined my thing and they found that I have it, but because of non-disclosure of this, I was rejected. But the honorable single judge in his order, my lord, comes to a conclusion that I did not have a bid capacity. There are two things, my lord, which go against me in the bid. Their basic case is, my lord, that I had not disclosed the works of the petition number 2, a director, while submitting my bid. Honorable single judge comes to a conclusion in the order that I could not have relied on the bid on the credentials of the petition number 2, which was nobody's case, my lord. Which was nobody's case. Now the effect is, my lord, because of this rationale that they have adopted, there was examination only in this case, my lord, 296. In the other cases, they have just copy pasted. And whatever works will now come, my lord, I'll be excluded. If I may take my lord through the papers now, my lord, page 39 is the tender, my lord. My lord, this is a work. My lord will only have the job number. It's EA 15/22/23/269. 39. Madam.
Which file you are in?
My lord, 296, madam. Oh, sorry, my lord. Sorry. Sorry. My lord, it will be 81, madam. 81. My lord, this is a work for around 19 crores, 29 lakhs. Completion is 1 year. The issue date was 11/4. And the last date of submission, my lord, is 11/5. My lord will have it serial number 2 just after the name of the work. Serial number 2, construction materials to be procured. The paragraph thereafter. The complete bid document can be viewed, download from the official portal of so-and-so from 12/4/23 to 11/5. Bidder must submit his financial and technical bid on or before 11/5/23 up to 4 hours IST. So my lord, 11/5 was the last date. Now, my lord, just to understand the why that works were important, my lord may have page 96, my lord, big capacity. 2.2.21, my lord. Bidder who inter alia meet the minimum qualification criteria will be qualified only if their available bid capacity is more than the total bid value as per clause 1.1.1. That
What
is,
about
my
Ms. Nair?
lordship,
Come to page 95 first.
95.
Probably that will be hitting your case.
Lordship,
The bidder including any individual or of its joint venture.
my lord, I am not here as a joint venture, my lord. I am here as a company, individual, my lord.
Okay,
I am here
This
as an
would not
individual.
this would not apply.
This will not apply, my lord.
Okay.
My lord, 2.2.21, page 96, bottom, my lord. Bidder who inter alia meet the minimum qualification criteria will be qualified only if their available bid capacity is more than the total bid value as per clause 1.1.1, which is 19.29 lakhs, my lord. Crores. The available bid capacity will be calculated as per the following based on information mentioned at Annexure 6, Appendix O. So, my lord, the formula, my lord, will only have page 97B, my lord. Value bracketed updated to the price level of the year indicated in table 1 note 2 below of the existing commitments works for the which the bidder has.
Emerged as the winner of the bids. This would come into your way when that aspect is looked into what the respondent says.
That I had not disclosed. For that, my lord, this has happened. Or that 10/3/2023 letter, my lord. My case is, if you have taken up a criteria, it should be applied uniformly to all.
All right.
Value for the works for which bidder has emerged as a winner of the bids or ongoing works to be completed during the period of completion of the work for which the bid is invited. This is important. For the sake of clarification, it is mentioned that works for which the bidder has emerged as the winner of the bids, but LOA has not been issued as on date before opening of the financial bid shall also be considered while calculating value of B. So, my lord, moment the financial bids in our tender process is done, according to them, I'll fortify that, my lord, with their statements. Moment that is done, you will have to disclose that, because that would be a work which would concurrently run with this work, my lord. Then, my lord, would have page 104, my lord.
So,
The
Ms. Nair,
clause, lordship,
if this is applied strictly
lordship,
for a moment to your client's case,
lordship,
and he has not disclosed that bid which has been opened just before this time.
lordship, I have not disclosed.
So you are in breach of this condition.
Yes, your lordship.
It's a different matter whether the same yardstick has to be applied
That
to
would
the
be
respondent
lordship,
in the other tender. That's a
lordship,
different thing.
lordship. I'm in breach.
All right.
Now, page 104, my lord. 2.6.1.
Yes.
The authority reserves, my lord, one thing, I'll just like to point out one more thing. In the technical evaluation that was done, this 10/3/23, that work was not a part, my lord, was not taken into consideration. It was only the works of the petition number 2.
Petition number 2.
That
was not a ground of rejection.
No, my lord. It came up subsequently.
Okay.
The authority reserves the right to verify all statements, informations, and documents submitted by the bidder in response to the RFP, and the bidder shall, when so required by the authority, make available all such information, evidence, documents as may be necessary for such verification. Any such verification or lack of verification by the authority shall not relieve the bidder of its obligation and liabilities hereunder, nor will it affect any rights of the authority thereunder. The authority reserves the right to reject a bid and appropriate this bid security if at any time a material misrepresentation is made or uncovered. The bidder does not provide within the time specified by the authority the supplement information sought by the authority for evaluation of the bid. Such misrepresentation, improper response shall lead to the disqualification of the bidder If the bidder is a joint venture, then the entire joint venture and each member of the joint venture may be disqualified, rejected. If such disqualification rejection occurs after the bids have been opened and the lowest bidder gets disqualified, rejected, then the authority reserves the right to annul the bidding process and invite fresh bids. So, my lord, the non-disclosure of the works of petition number 2 was taken as a misrepresentation. Whether, my lord, it per se would come within the term of misrepresentation, it's a different question altogether, but it was taken, my lord. Now the evaluation, my lord, page 181.
180?
181, my lord.
180.
It was done on 14/6/2023. My lord, the relevant would be 182. My thing, my lord, serial number 3 thereof, my lord, somewhere in the middle, my lord.
Yes.
Purbanchal Buildtech Private Limited. Based on the representations received regarding the concealment of existing commitments by the bidder so-and-so, necessary clarifications were requested from the relevant heads of the directorates. Specifically, CEPWD border roads through TO number 25/5/23. In response, the CEPWD border roads Assam through letter dated 26/5/23 has confirmed that the bidder did not disclose the mentioned commitments in their bid. The deliberate misrepresentation of facts renders the bidder liable to be disqualified as per clause 2.6.2 of the request for proposal, and the bid security shall be appropriated accordingly as specified in the clause. Consequently, the bidder is considered technically non-responsive. Now we have come to learn, my lord, it was the private respondent who had brought this to the notice, and they immediately, my lord, on 25 issued a letter. On 26 itself, the response came.
Response
from the CPWD border roads.
All right.
And the issue here is, while NH, this was issued by NH division had transferred the works to me. It's on record, madam. Whereas border roads continued that works in the name of the petition number 2. Till today, the payments are made in his name.
All right.
Now, my lord, the works which I had not disclosed is at page 184 onwards. Till 187. Now, my lord would have page 214. My lord. That's one of the part of the technical evaluation committee's proceedings. My lord, this is the assessment of the bid capacity, my lord. Here, my lord would find in the right-hand side, last top portion, Purbanchal Private Limited 6 Mile Partnership. My lord, it is, the required value is 19.29. It has 55.65. And my lord, but that comment is there just below that, that as I have not disclosed, so he is disqualified under 2.6.2, my lord. Now the findings of the Honorable Single Judge. My lord, it starts at page 216. I just have my lord's relevant portion. My lord. My contentions is what I just submitted before my lord. Para 16, my lord. Page 22.
Page
229, my lord.
All right.
Per contra, the Learned Standing Counsel for PWD has submitted that the petition number 1 company was availing the benefit of experience and credentials of the petition number 2, namely Mohammed so-and-so, one of its directors. Therefore, the petition number 1 company ought to have disclosed the pending works awarded to the petition respondent number 2, which were not assigned to the petition number 1 company, which was required to make an assessment of the total bid capacity of the petition number 1. Now, after this, page 230, 18. It was also submitted that the value of the work for the last 5 years was required to be taken into consideration, not the entire tenure of the pending works. This was explained by submitting that the tenure of the present work was 6 months. Actually, it is 1 year, my lord. But the petitioner is having another work which has a tenure of 18 months. However, for calculating bid capacity, the value of work which was to be done during the tenure of the tendered work has to be considered, not the value of the entire previous work. 19. It was submitted that the independent of whatever the bidders had disclosed in the bid, The bid evaluation committee had taken into consideration all relevant factors and following value was applied in respect of the formula for determining the bid capacity of the petition number 1 company. That is, my lord, my bid capacity came as 0.44, which was less than the required total bid capacity. Accordingly, it was submitted that the technical bid of the petitioner number 1 company was evaluated as non-responsive. My lord, barring that page 214, there was nothing, no other material produced before the honorable single judge.
Where does this figure come from?
I don't know, my lord. Then, my
Part
lord,
of the
would,
pleadings,
lordship,
is it indicated anywhere in the affidavit?
no, my lord. Because no affidavits were as such filed there.
Only notice has been issued.
The only notices were issued.
So we are against an interim refusal. of
Interim
interim
refusal of that.
Against
Interim refusal of that.
So now, the matter has to be agitated on merits. Till then, you don't issue the work order then. Well, if you want, then we can express our opinion here and decide the matter finally. Or else you can have your chance before the single bench. But then, prima facie, we'll of course hear you. But prima facie, if such an extensive order, detailed order has been passed, thereafter, keeping the two things, keeping the writ petition pending or denying interim relief. Both things, then it is virtually a fait accompli.
Here, kindly see the writ appeal, the prayer made in the writ appeal. In fact, in the prayer, they have prayed for setting aside of the minors, the relief which is pending before the.
Let us see. Let us see.
Page
Let us
41.
see. Page number.
Page number 41.
Order.
The relief.
First relief is order.
First thing is
So
order.
the first relief is order. Set aside the order, grant and stay. That is what the order was, refusal of interim relief.
Lordship.
That is challenge.
Yes.
Ancillary reliefs, they thought that doesn't make any difference. So if you want that we should decide the matter on merits, we can very well do.
Well, all the petitions are pending. In fact, action has been taken by the authority against them. So, let it be decided on merit. The petitions are pending. Let it go there.
So then don't decide it. Then don't close the doors of the appellant finally. Make a commitment then.
Lordship,
Rather than taking our opinion, because if you take our opinion, it may work either ways. We are not making any comments what will be the fate.
Correct.
But till the judgment is, the writ petitions are decided, don't issue the work order there.
Well, Lordship, the work is in the public interest. Work is urgent for us.
Urgent and all right, we'll decide it on merits.
Lordship, within a time frame, let it be decided by the petition.
Till then, you don't allow the things to proceed.
In
Two things will have to be done. If we send the matter back to the single judge, one, the observations made in the impugn order can't be considered. They are prejudicing the case. And second, the matter has to be decided on merits without being prejudiced by. And third, the works have to be stayed till then.
Let them proceed with the processing, my lord. Let them not issue the final order.
Yes, don't issue the work order. You can proceed till then.
But there are 4 writ petitions. In fact, the others, the petitioner is not hesitating as regard the work, because he is not L1.
But
In this,
There are 2 appeals here.
2 appeals here.
So in the second one, he has already said
second one also he said.
that he is not the L1, so he is not bothered about.
Lordship.
Before your lordship has expressed.
Then all right, let's continue on merits. We'll decide the matter on merits. If you have any objection to this suggestion, then let's decide.
Subject to what comes from your office. Well, at first point, what I could hear from my connect panel is that so for suppression of the work of March, the tender was in May. In April itself, affiliate security everything has been deposited and.
Mr. Kumar, that is not a ground of rejection or technical disqualification.
And second, he has said.
Mr. Kumar,
Yes.
first answer what you have raised an argument. We are responding. Now you give an answer to that. That is not a ground of rejection of his bid.
Well, a rejection of the bid was for he has.
It may be done in future. That's a different thing. But for present, that is not a ground.
Well,
And then he is raising an argument, same argument against you.
no, that I can take care of, my lord. That I can take care of. I have brought it on affidavit. The tender was closed on 12. The letter was given on 11. Competitive statement was made on 13. Only on 13 I came to 12. I came to know that I was the lowest bidder. That is factually incorrect.
Okay, very
So
well.
far March that case is concerned.
That-
So far March is concerned. Well, moreover, Malak, he has said that so far National Highway has distinguished between the petitioner and the competitor. But it's in this case also for assets He is showing his individual.
That is
work.
why, Mr. Kaur, we are saying, let the single judge take a call on that. Let the single judge decide. Why you are foreclosing the right of appeal of either of the side? If you want to do that, we'll hear and decide, whatever the fate be. It's a different thing, but after hearing you, we may have a different opinion. But for the present, we feel that once this much of time had been spent, then the writ petition itself should have been decided.
There also, my lord,
Leaving the parties hanging in this manner is not at all a very happy situation.
it's neither for us, neither for.
Anyone, we are not commenting on the
Because,
appellant only.
Because these are all public interest projects, madam.
Yes.
Your lordship will kindly see page 269, what he has done. Even after that, if your lordship demands the matter to the legislature, I have to.
No, we have nothing to remand. Question is, the matter is already before single judge. All we are suggesting is that till that, let the process go on. But don't issue the work order till the writ petition is.
And in terms of the melody, that is so, madam. In terms of the orders of the Supreme Court, if in case the petition is dismissed, then for all the escalation costs and all.
Yes, he will be responsible. That we will take the undertaking.
Yes, madam.
We'll take the undertaking. Yes.
Your lordship will kindly see page 269, paragraph number 10 of the affidavit filed by the state PW.
Yes.
The respondent said that the company submitted 3 projects in details of eligible project, that is project code so and so, so and so. Out of the 3 projects shown by the bidder, project code B, improvement with widening of so and so and so and so, so and so, so and so, which was allotted to and completed by Mohammed Ahmed, and the authority for which the project contracted is Public Works Department, Border Roads, Assam, Sanmari, Guwahati, which substantiates the fact that the company Purvanchal Buildtech Limited had inherited the credentials of Matlabuddin.
How can there be any such presumption?
They have shown the individual work of Matlabuddin in the PWD work in the present case.
That is, Mr. Kamar, we are not substituting our wisdom for the wisdom of the authority. Let the authority take a decision on that aspect. If that is also a factor against him, let it be decided in that manner. There is a clause in the tender by which they could have sought additional information, and then they could have decided. In that event, even that work which you are pointing out, that would have been brought to record.
Yes,
You understand? For the present, it is only on the basis of one fact that works of Matlubuddin Ahmed were not disclosed. That's what their case is. They are not works of company.
No, they have not disclosed the work of Purvanchal.
March.
First is March.
That March, yes, that's what we are saying. That is not a ground for technical evaluation.
But they can even take a call now also.
That's what we are saying.
But that probably they are scared to do it because the matter is sub judice before this.
That's what we are saying. That once the matter comes up before the red court, this argument can be raised, and that would go against them, obviously. That risk they are ready to take.
That with utmost respect, madam. Number one, your lordship will decide. And in case of dismissal, they have to bear the escalation process, which is how it is in the collapse. Number one. Number two, that this will also not preclude the state PWD from issuing them a notice and taking into account all these factors also.
Yes, Mr. Nar, is your client ready to take that risk? Because on that count, you are bound to go.
Yes.
That is for sure.
But my lordship.
You don't go on negative equity that he did not disclose. You make a complaint against him. Whatever fate befalls.
I have already made, I have brought it on record, they have done nothing.
All right, they will do it.
That much.
They will do it.
If that criteria is uniformly applied, I have nothing to say.
Mr. Nair, from what Mr. Kamar says, even the information came around after the last date of filing of the bids. So where was the occasion?
No. My lord will have page 292. And my lord is having the affidavit of the respondents. My lord had read para 10. My lord will come to para 13, my lord. 271. The last 4 lines, my lord. Or my lord will have the whole paragraph, para 13, 271. The deponent respectfully states that as per stipulation in so and so of the existing works of the bidder has emerged as a winner of the bids on the ongoing works to be completed during the bid so and so is invalid. For sake of clarification, it is mentioned that works for which the bidder has emerged as winner of the bids but LOA has not been issued as on date before opening shall also be considered as calculating bid. Therefore, as soon as a bidder is declared L1 winner of a bid in any tendering process, the bidder must count the same work as his existing commitments in all subsequent tendering processes.
Yes.
Now, my lord, 292.
Their reply.
Yes,
My lord, this is the summary of that work.
Sanjay Kumar Singh.
Sanjay Kumar Singh, my lord will have the last part. This was, my lord, uploaded in the website on 10/5/23 at 3:04 p.m., my lord. And he was declared L1. Subsequently, what they did, what my friend is trying to say, on 12th, they took out downloaded a copy of all this and then signed it.
So
But
we'll make an observation that this objection of yours regarding he not having disclosed, that will also be brought to the
That much
notice of
only,
the
that much only.
and that will be accounted for.
That much only. That much only.
We'll make that observation.
Since the
Just for. Well, you kindly see page 341.
First, come to page 292, Mr. We are not concluding
No, no,
anything.
no, no, but
We are just
this is
saying.
my London Fed. I have enclosed the document in my affidavit at page 341.
Do you dispute the fact that it was uploaded on 9th May,
10th May, man.
10th May? Where is it?
But
Fact-
your lordship will see
Where is the
page
fact of uploading, Mr. Nair?
My lord, that 292 itself, my lord.
Read.
292 itself.
Updated on so and so.
So on date.
No, that is 9th May updated.
No, down below, my lord. Finance bid opening ceremony, finance 10/5/23, updated on 10/5/23.
Updated. That's not uploaded.
DOQ comparative start. Then he comes, my lord, L1.
But
There,
uploading date, where from do we
that
get?
is the date, my lord, updated on.
Updated, there are two
They
updates. Updated.
updated in the, my lord, site.
Okay.
In the first date is 9/5 with regard to, my lord, the technical evaluation.
304.
And then
when
on
did he-
10,
When did he file his bid?
11/5 to 2 p.m., my lord,
11/5.
2 p.m.
Yes.
My lord,
You are referring to page?
page 341.
Hmm.
This was the message sent to all the bidders whose bids were found admitted, my lord, at page 341. Then your lordship will see, and this was not sent to me only. That case, page 342 is the competitive statement, which was made on 12. Your lordship will find this at the last page, the signatures and all this. Only on 12, we came to know that that we are the L1.
So you will have a right to object.
Yes.
You are just giving them the liberty to raise that objection.
Since they have said, that's
We
why.
just say that same objection, if they want to raise, they may raise before single bench.
But now they have to take the risk, madam.
But they obviously stand at the risk.
Yes, yes.
That Mr. Nair is taking a calculated risk. Let him do it.
Yes.
His client must have given that instruction.
Because, my lord, it's now
We will.
bread and butter. My whole livelihood is in under threat now.
Mr. Nair, we don't know, but the fact of non-disclosure of the March bid, that is an admitted fact.
That will settle.
Then that's a fatal thing to your
So
client.
I'll try to justify that, my lord, by saying that this was not uniformly applied, my lord.
All right.
If that, because, my lord, there is a logic.
Seems to be an illogical
No,
argument.
my lord, there is a logic behind that. Why
Alright.
this was not
We are
disclosed?
not going into that.
Logic.
The instant intra-court writ appeal is directed against the order dated, order in judgment dated, order dated 31/7/2023, passed by learned single judge in WPC number 3958/2023, whereby, the prayer for interim relief made by the appellant in the writ petition challenging rejection of its technical bid in a tender process initiated by NIT dated so and so for the work described as so and so was denied. Post hoc. Mr. Nair has raised several grounds for questioning the justification behind rejection of the prayer for interim relief. He urges that the learned single judge has already expressed his opinion on the merits of the matter and thus, passing an order rejecting the prayer for interim relief without finally deciding the writ petition, would lead to a situation wherein the appellant is left remediless on all counts. He further submits that on almost identical grounds on which, the appellant's technical bid was rejected, the same hurdle is operating against the private respondent who has been held to be the responsive bidder, but the authorities have till date, not taken any action against the private respondent in that regard. Full stop. And counsel, Mr. Kamar, representing the private respondent number 5, and Mr. Nath, and senior government advocate, submit that it would be better if the writ petition pending before the learned single judge is decided on merits, because any decision on the merits of the matter by the division bench in this writ appeal would foreclose the right of appeal of the parties concerned. In this, Mr. Nath assured that till the writ petition is decided, the work order shall not be issued to the respondent number 5. In view of the submissions noted above, we hereby observe that we hereby request the learned single judge to decide the pending writ petition number 3958/23 expeditiously, without being prejudiced by any of the observations made in the order dated 31/7/2020. Needless to say that the appellant shall be at liberty to raise all objections regarding the qualifying criterion applied by the authorities by adopting means of discrimination.
Lordship, I kindly observed about the liberty to the authorities. If the materials have come now,
In case, it was further made clear that in case the petitioner loses in his challenge to the rejection of its technical bid, all consequences will follow. As per law.
that is one part, and the other part, Lordship, the liberty to the authority, since the materials are available, if they want to just take clarification from them and take a fresh
Clarification
decision.
from all, man.
It is also made clear that the authorities concerned shall be at liberty to
Revisit.
take recourse of clause in the intervening period, the authorities on the request of Mr. Nath, it is further clarified that the tendering authority will be at liberty to take recourse of clause
2.6.
2. So and so of the tender conditions for seeking explanation of the additional information from the parties. That is all right, Mr. Nath?
2.6, Lordship.
2.6.
2.6.
2.6.
Page 104.
Yeah.
Lordship.
All right, it's better. Take
That can
information,
be.
take a decision.
Yes, yes.
That would,
Decision they take will be placed before the learned.
that is bound to come.
Lordship.
Much obliged.
The rate appeal is disposed of for
The
in these
other
terms.
one, my lord.
And the other matter
Other one.
that counsel Mr. Nair frankly concedes that the appellant as financial bit of the appellant is not, does not qualify him for the work in question, and hence
But my lord, there
the
are,
rate appeal may be closed.
there are certain observations in the, similar observations in that manner wherein said that I cannot use the credentials.
The
but it will
observations made in the order
31.
given in this rate appeal shall not work to the prejudice of the appellant in any future tender.
My lord, that rate has to be heard, my lord, because that security deposit, that is there. my lord.
Petition is pending.
Then all right, both rate appeals are disposed of in the same.
Yes, sir.
Lordship.
Forget about that.
Lordship, the order of the direction of not issuing the work order will be only in.
296.
In rate appeal,
In
the
296.
direction in view of the fact that the appellant's bid, financial bid has been found to be lower.
Low.
In
Higher.
rate appeal, higher in rate appeal number 302. Higher means what?
No,
Higher means, my lord, I had given 24 crores. The bid went for 20 crores.
in 296 only, they.
Since the appellant has not qualified on the financial aspect of the matter,
Lordship.
the authorities shall be free to proceed with the issuance of the work order.
In other.
Item number 302.
Lordship. That- Much obliged.
To be granted to all of us to make a mention before the learned will just.
Land council representing the party are given liberty to request the learned single bench to expedite the disposal of.
Lordship. Lordship.
Highest disposal.
Item number 41 and 42.
Lordship. This case is relating to my lord appointment of distributorship for LPG money by the sole authority, and advertisement also made inviting application, my lord, for appointment of LPG distributor for Jamlai area. in
Yes.
Interim, which is termed as my lord Durgam Kshatriya Vittar category. The petitioner also applied, my lord, and he was in the first lot of draw, my lord. He was selected as first. Thereafter, without giving any show cause, without giving any notice, they went for second draw. And the respondent number 4 was selected and she was appointed as the distributor for that particular Jamlai area. The learned single judge has set aside the, my lord, impugn order, my lord, of her appointment. But my lord, he has not give any, issue any direction regarding my appointment. Since I have challenged and I have been deprived, and my lord, that is in page 62, my lord. Sometime, my lord, page 261, it starts, my lord.
Why
The learned
read
counsel-
27 subpara 2, the direction is there.
Two, my lord, the respondent 120 are given the liberty to bring to logical conclusion the LPG decision in respect of Jamla advertised location in accordance with the guidelines of so which such time as deemed fit to the authorities concerned.
So the direction is already there.
No, my lord.
Why?
No direction. If your lordship read the above paragraph, my lord, he has refused to issue a direction. My lord, done through so and so. It appears from the record that apart from the petitioner
Yes.
and the
You have
respondent.
12 other eligible applicants.
Yes.
Yes.
The applicants
So
are under such circumstances, the question of issuing a direction to the respondent as authorities to issue a letter of intent
Yes.
and letter of appointment to the petitioner.
where is
not
the
arise.
LOI?
Do not arise.
Was a LOI issued to you?
No,
Then
I was selected only.
selected, where is the order of selection? Where is the order of selection?
Order, my lord, it is my lord in the computerized, my lord. It is not a disputed fact, my lord. If your lordship
Let us
kindly-
have a read-
It
look
is
at
in my lord, page 55. Page 55. My name appears
the-
in the first.
A priority list. All right.
priority list.
Yes.
Thereafter, my lord, in that affidavit in opposition, page 126.
126.
Here, my lord, the page 127, paragraph 5. And the petitioner was selected for the first job lot, which was held on so and so. On which Ralsona Pal was declared as the selected candidate for the location Jamla, and after his selection, certain verbal complaints were raised on. So, my lord, I fulfill all the criteria and I was selected, and without giving me notice, why they have not the
there
reason
for
given
the
in the
IOCL?
affidavit position.
You are there for the IOC.
I am for respondent.
Respondent 4.
Respondent number 4 has no cause of grievance now. Have you filed an appeal?
My lord, question is, my lord, when first lot of draw selected by the.
Dear sir, your client has been non-suited by the single judge. You have not filed an appeal.
I feel also item number 42.
Your appeal is there. All right.
Let
Okay.
me submit
Now, my
my
lord,
lord, few
my lord.
lines, my lord,
Yes,
few lines.
Yes.
I want to complete. In the affidavit of opposition, it is stated, my lord, I have filed 2 applications. For that reason, I want to read, my lord, that page 28, my lord, according to the petition.
Page 28.
Yes, my lord, 128,
128. Yes.
same para, my lord, I am containing verbal
Applied
complaints raised
twice,
by the
yes.
other appellants who were present and draw and Watson applied. The petition has applied twice, and as such, his candidature should be cancelled. Later on, a formal complaint was also received on so and so from one Nandita Das against the selection of the petitioner, stating that he had applied twice. The matter was thus examined by the authorities, and it was found that the allegation raised in the complaint that so and so was true. Accordingly, the petitioner's selection for the Jamla location was cancelled against the application number so and so and so and so. Here, my lord, there is a guideline. So, my lord, which says that
Yeah, Mr. Chaudhary,
if there are
first question
separate
here.
application also.
Just hold on, madam. Mr. Chaudhary. First question. Selected candidature cancelled without hearing.
No, my lord, I think my learned friend has not placed the facts correctly. It was said, my lord, by that order that since you have filed two applications, one application is cancelled, we will consider one application only for the draw of lots.
Whatever, sir.
My lord.
In the draw of lots were two of the applications were referred. Or one application was referred, first draw of lots.
She filed, my lord, two applications. Or both
In
these
the draw of lots,
Online.
whether you kept two applications or one application.
only one application.
Then the consideration was of one application only.
Yes.
Then if question here is a selection done, communicated, could it have been cancelled without providing opportunity to show
selection has
cause?
not been cancelled, my lord. One of the two applications has been cancelled because that.
All right, sir, read 128.
That's 120. That's the part of his retribution.
Read the seventh line from the top. Accordingly,
Matter was thus examined by the authorities and it was found that allegations raised in the complaint dated 3/8/2018 was true. Accordingly, the petitioner's selection for Jamla location was cancelled against application number such and such and he was informed about the cancellation of his application number such and such by letter having reference number such and such.
so the selection
Two applications was cancelled, my lord.
immaterial, sir, there was a selection on one application.
Yes.
If you wanted to cancel it on the ground that there has been a misstatement or a misrepresentation or two applications,
Yes.
you are supposed to seek explanation.
No, my lord, that is not the requirement of the my lord guidelines. Guidelines say that they can only file my lord one application. They cannot my lord take two chances. So one chance is given, one application has been considered and the draw of lots was taken on that only, my lord. If your lordship kindly comes to this my lord guidelines, page 32. Clause
Yes.
10.
All applications will be clubbed together. And application fees would be forfeited. What is the difference?
Application should submit only one application.
All right, it is not fatal if the applicant submits two
It is
applications,
fatal, my
not
lord,
fatal.
because one application applicant will get two chances of in the draw.
Mr. Chaudhary, your guidelines do not say that filing of more than one application is fatal.
Your lordship will kindly say, my lord, no, her candidature has not been cancelled, my lord. One application out of the two applications.
Question here is, sir, you did not give her two chances on one separate applications. You considered one application.
Yes.
In view of this guideline, it is presumed that the other is clubbed in this. That's all.
So there ultimately it comes to one application.
One application that has been treated and she has been selected. Where is the question of cancellation?
Says, no, my lord. It is a computerized draw of lots, my lord. On the draw of lots, only one of the application of the petitioner was, my lord, taken into consideration.
Guideline says, sir, if there are more than one applications, it is deemed that they will be clubbed together.
Yes, that is only.
There is no prohibition in filing more than one application.
My lord, if your lordship kindly come reach my lord clause 10.4.2. One application per applicant for a location.
Yes.
Applicant should submit only one application for one location. In case more than one application is received from an
So it
individual.
contemplates filing of more than one application. The only consequence is that you will club them together.
Yes. So
All right, you have treated our application. It is presumed that they are clubbed together. All that consequences, application fees will be forfeited against the remaining application.
Yes.
That is the only consequence.
True, my lord.
The party cannot be non-suited on this ground.
No, they have not been non-suited. my lord.
Then the selection, why it was cancelled, sir? Is the filing of more than one application, does the filing of more than one application lead to a consequence of cancellation of selection as per the guidelines?
My lord, both the applications were, my lord, separate. And the father's name was different in the two applications, my lord.
Then you were supposed to give a notice because you already selected once
We have given a notice, my lord.
before cancelling.
Yes, my.
Show us, all right.
Your lordship will kindly come to page 138.
Yes, please. All right. Let us see. 138.
This is to the applicant, my lord, appellant. Application for award of LPT distributorship
Please refer to your application number YOC so and so for award of above mentioned LPT distributorship. We like to mention here that your name as per application serial number such and such appearing at serial number 1 of the candidate, Sri Doyal Chandra Pal, son of Sri Santosh Pal, with application of the list of eligible candidates is same at serial number 4 with application number such and such. This happened because you have changed the spelling of the name of your father at serial number 4. Sri Santosh Pal, which the system could not detect, and your name appeared twice in the name of eligible candidates, and your application number such and such got selected in the draw. As per our guidelines, the name of the applicant is considered only once at the time of draw. Hence, your selection in the above draw with application number such and such is rejected, and the redraw will be considered.
Is it a notice before rejection, sir? Is it a notice before rejection? Coming from a learned senior advocate of this court that yes, notice was given. Really, we are left to rethink what the process should be.
Now, my lord,
And Mr. Chaudhary, look at pay and accept pay 55. The list doesn't say that there were two names reflected or twice her name was reflected. It's only once.
no, that is what this says, my lord. In the computer, my lord, what is the ultimate effect of the Honorable Single Judge's order? Honorable Single Judge has set aside, thereafter redraw was held, and the private response number 4 was selected. That selection has been cancelled now. What is there, my lord, for the petition appellant to be aggrieved now? Because, my lord, as per the guidelines, we have to hold the draw again.
Mr.
And what
Chaudhary,
will be
the appellant succeeded in the first draw of lots. What is wrong in that? If you are putting a question to us, we are putting a question to you, then answer.
No, applicants, that particular application was rejected, my lord, because of this order 138.
Very well. Okay, that's all. Admit stay.
And this has not been challenged, my lord. This is not on the challenge, and your
There was hardly 10 days time given, sir,
my lord.
before draw of lots. What the applicant was to do.
No, when the, my lord, comes before the court, my lord, this is also not under challenge.
Okay.
And your lordship will see what is the prayer made in the writ petition. That
Okay.
should be given here.
Admit impugned order shall remain state. Your appeal, what do you say, sir? Yes.
We are not on appeal, my lord.
Yes,
Hmm?
you are
We are not, IOC is not on appeal, my lord.
Now we know.
Yes, my lord, stay, our application is there, my lord, for stay, my lord.
What can be the stay? We'll hear and decide whether their action is correct or not.
They invite application again, the complication will arise, my lord.
In
Advertisement,
the meantime,
application will arise.
I would like.
Application for fresh application, it will complication
There is no
arise.
fresh application shall be invited for the location in question.
Kindly lordship, I will make this.
We'll admit your appeal also. All right. Admit issue notice.
And lordship, I have also filed one, my lord, here. Regarding my lord, I have already entered into agreement with the IOC.
Doesn't matter. Doesn't
And
matter.
I
We have
have,
stayed the
my
entire
lordship,
process.
and I have a contractual right, my lord. And I have already.
Enforce it in the court
I
of
have
law.
already constructed my lord, LPG go down, my lord.
No, doesn't matter.
And my lord, the.
That is why we have admitted your appeal, sir.
Lordship.
The matter will be listed, my lord.
And
List
the-
for hearing
and
up to
the
4 weeks.
lordship Respond, petitioner also. Already, my lord, and lordship, page 64,
Mhm.
he had participated in the second,
Yeah, that's right. How much time was given?
but when participated.
Yes. So
And
was there any option after rejection?
And fast lucky.
Was there any option after rejection to challenge and to participate? Whether
What is participation? I don't
Challenge, my
know.
lord.
what order has not been challenged? Rejection of the bid has not been challenged.
Not challenge. but
Let us see.
Only saying, my lord, that I am not a permanent resident. That is the issue.
Let's see. What was the challenge in the writ petition, madam? Let's see your prayer.
Yes, my lord.
Whether the order was challenged in the writ petition.
Which one that?
Hmm?
Order is challenged, that's why this set aside, my lord. Impugned order is set aside.
No, no. The order whereby your candidature was rejected. Did you challenge it? Let's see.
Yes, my lord.
They had participated in the second.
The order dated?
My lord, the writ petition, my lord, in my appeal, my lord.
Being eligible. Yes, my
Prayer
lord.
prayer of the
Place
writ
38,
petition
my
is
lord.
31. Prayer of the writ petition
Place
is
38,
31.
place 38, my lord.
Page 38.
Eight.
No.
31. In my,
38.
in my.
No, my petition, my lord.
Hmm.
The father, first, my lord, to set aside and cause the letter of intent of so and so issued to the husband of the ISL authority.
Hmm.
Further, the petitioner being eligible candidates, he shall be selected and appointed as distributor for LPG category so and so. Jamla, passes order,
That covers.
in the submission, it is there, my lord. regarding my lord.
All right.
And my lord,
So two prayers.
All right, so we'll hear you finally in the order on interim relief in writ appeal
If it
325.
is, my lord, before Puja vacation, because the earlier writ petition was
We'll
wait for
see.
so many years, my
Yeah.
lord, before of the lockdown, my lord,
In the meantime, and till further directions come out,
or after
The-
2 weeks. So.
respondent IOCL shall not re-advertise the location in question for issuance of a dealership.
Obliged.
And Lordship, my LPG
Alright.
go down shall be continued.
No.
Then I can go to-
Absolutely no. There's no question. You have been non-suited. Next.
Obliged.
Item 43.
In this matter, my lord, I have received the instructions. My lord, I have given the instructions. This is with regard to because they were finding it difficult to trace out two records. And my lord, presently the records are lying in the Court of Chief Judicial Magistrate, Bongaigaon.
What is the matter about?
No, basically they wanted, there was a DV case and 125 CRPC proceeding, my lord, wherein maintenance was given. And thereafter criminal appeals were filed before the session judge. And the criminal appeals were dismissed and they wanted to file execution petition of DV proceeding and 125 CRPC proceeding. My lord, they were finding it difficult to file the execution
Because the
petition
records were not
because
available.
Records were not available, my lord. I have given the instruction, my lord. As per the instruction, the records are available in the office of Chief Judicial Magistrate, Bongaigaon, my lord.
What more do you want?
No, and that is my prayer. So you will file petition and of course, biller shall do the.
You file the
needful-
application, the records are available. In reference this to you file the application. They're disposed of.
Obliged.
Deeply of it.
Item number 44.
Yes.
Please, Your Honor.
Yes, please.
The respondents were directed to file affidavit, but not has been filed.
There was no direction to file affidavit. That day, my lord, the.
Respondents to file their affidavit within a period of 1 week from today.
My lord, yes, but I can, my lord, satisfy your lordship from the writ petition itself, my lord. The issue is this.
File a formal affidavit.
I'll do
It's
that.
better.
I'll do that. My lord, we'll have it on Wednesday next. I'll file it by.
Yes, Mr. Senior Counsel, Mr. Nair appearing for the Guwahati High Court. Praise for, and is granted short opportunity of 3 days to file the affidavit. Re-notify on
Wednesday,
27th.
lordship.
No, not 20, 30th.
30th, lordship.
30th.
Obliged, Your Lord.
Item number 45.
Lord, I appear for the applicant in this matter, Your Lordship.
Yes, please.
My lord, this matter is related to the portion of the notification of 1965 by dint of which both sides, half a mile of both sides of 16 rivers were declared and notified as reserve forest. My lord, by the impugned order dated 27/1/2021, the single judge quashed this notification. Your Lordship. Now, my lord, the IA has been filed by respondent number 9. NIPCO. If the IA, my lord, kindly sees the IA. First, my lord, the first submission is I need to file a reply to the IA, but my lord, kindly sees once the page 197. Para
197.
My
197 in the appeal.
IA, my lord, IA has been filed, Your Lordship, and IA
IA.
respondent number 9. I'm being served a copy of the IA.
There is a sir rejoinder which has come today. Have you got a copy? Is there any IA in this?
Sir, rejoinder has been filed by the state of Mizoram, Lord. Yes,
right.
May I, my lord?
Just let us have the IA, madam. We not got the IA. Yes.
Now, your lordship, if my lord kindly sees page 197, that is para 10 of the I. From the last 8 line, may I read, my lord?
Yes.
Subsequently, the private respondents number 1 to 19 filed execution case number 6 so and so for executing the common judgment in order dated 27/1/2021 before the senior civil judge Aizawl district, which is the subject matter of the instant written. The said execution applications were dismissed and by separate order dated so and so passed in execution applications so and so. Order dated 3/2/23 passed in the execution application so and so are assailed by the private respondent in civil revisions number so and so, and the civil revision petitions are pending before the single judge of Aizawl of the Honorable Court. Since the subject matter, para 12, since the subject matter of the instant writ petition so and so, this is this instant writ petition, and the civil revision so and so are same, is challenging the common judgment and order dated 27/1/2021 and execution of order 2021, the same are required to be heard together along with the instant written. Now, madam, there is two submission. One, the subject matter of this IA, that is the order dated 3/2/23, and the civil revisions are not annexed to the application. First. Secondly, my lord, section 115(1) of civil
CPC.
CPC, my lord.
Yes.
Yeah, no appeal lies against the order. Where there is no appeal against an order, in that case only a civil revision can be filed.
Yes.
Now, firstly, 3/2/23, the order, which is the subject matter, is not annexed. Secondly, the order which is the impugned order in this appeal, my lord, that is 27/1/2021, that in that the execution of that order has already been dismissed, and therefore against that order, which is challenged in challenge before my lordship, a civil revision cannot be filed. That is my submission, your lord.
We are not seized of the civil revision as such. Why should we comment on that? Let the
Yes.
single judge exercise jurisdiction. That objection can be raised before the single judge who seized of the revision.
Mine.
Yes. What is the matter about? What is this appeal about? Let us know. What is the subject matter of the appeal?
Well, subject matter of the appeal is the order dated 27/1/2021, by dint of which the single judge have quashed the notification dated 1965. My lord, I have yesterday received an reply from the state of Mizoram. In that case, my lord, I seek 1 week's time, and my lord, can you fix any date so that the matter can be heard?
Lord, that IA 2042 is filed by me. Now, here, your lordship, the subject matter of the related third party writ appeal is the order dated 27/1/2021. Some of the respondent lordship have already made an endeavor to get the order executed during the pendency of this writ appeal. And that execution petition was opposed by me and rejected. Against that, they have gone for CRP. So I have filed this application, the records of those CRP.
Why you make an application before the single judge that since that order is subject matter of challenge, there cannot be any execution.
Similarly, your lordship, I have, as per my lord's direction on the last of the occasions, that application is filed here. That your lordship will see the order. Order dated 16/6/2023. Mr. Jindal is permitted to move an application seeking such a grant. So, your lordship, my humble submission is this: let records of
Get the revision disposed of, sir, in light of the fact that the order is sub judice before this court. You simply need to go there and tell the judge, single judge concerned.
No, since my lordship applications are filed, my lordship may just.
No need to call that file, sir. No need to call it all.
We have already informed, they say that that is an order.
Let the order be passed then. Let the order be passed. If there is any adverse order, we'll see.
Lordship, that may be hard together. And here, my lordship, the issue is this, my lordship. In fact, the entire land in question was a forest land, and I have constructed the hydro project over that land by paying compensation for forest deforestation. Now, even after paying that compensations, they are passing the collector has passed the award against me, and there are number of judicial pronouncements by which it is held that NIPCO is not responsible for making any payment. Now, third party writ appeal has come. Writ appeal has come wherein in two cases it was held that the notification which was issued for declaring the land in question as a forest land is set aside. Is set aside, meaning thereby that it is not a forest land. So therefore, this third party writ appeal has come. So, Your Lordship, it will be in the interest of justice and my humble prayer that the CRP which are pending before the one of the bench of this honorable court may also be called here and heard together so that the issue can be.
They sought execution of the judgment of single bench by filing an execution.
Yes, Lordship, for which the appeal has been filed. And they are executing the order of the single judge.
Then we will simply observe that since the appeal is pending, there will be no execution. We can observe that. Yes, what do you say, madam? The appeal against the order is pending. Where is the question of filing an execution? All right. IA number so and so.
Your Lordship, this observation may be made in the
IA number so and so. In writ appeal, you will write, and counsel for the appellate prays for time to complete her instructions. IA number so and so. The respondent number so and so in the writ appeal has moved this. Respondent number 5 has moved this interlocutory application seeking transfer of the case records of CRP number so and so pending before the Aizawl bench of this court to be heard together with this appeal. We find that the parties concerned, moved applications seeking execution of the judgment dated 27/1/21, which is subject matter of the connected writ appeal in the civil court concerned. First up, the applications were dismissed and thereagainst, the aforesaid civil revisions have been preferred.
No, this is the order dated 27/1.
They have referred to the judgment dated 27/1. Seeking execution of the collector's award. The fact remains that the judgment dated 27th January 2021, by which the acquisition in question was set aside.
Acquisition question was, no, land in question was declared not a forest land.
Land in question was declared to be a non-forest land. It's subject matter of the challenge in the writ appeal. Hence, till disposal of the hence we hereby direct that till disposal of the writ appeal, the proceedings of the civil revisions referred to supra shall remain in abeyance.
I leave it. The next date.
Just one. What Ms. Yes.
I am on behalf of respondent number 682, my lord. Here, appellant has filed additional affidavit, my lord. That is wherein para 12 they have clearly stated that they do not have any objection if construction part is going on, paying due compensation to the affected parties. In this regard, I have to submit that already as per instruction of competent notified land acquisition, that is additional district judge of additional deputy commissioner, we have paid already disbursed with 81 crores to them. And due to stay order operating, we are unable to go acquisition work.
Is now in this appeal.
Yes. Thereafter, what happened? We got implemented as our works have been hampered. Earlier, we are not in this case. But when works have been hampered,
We'll decide the appeal shortly and after. In the next month, we'll hear and decide the appeal.
But they, according to, yes, my lord, then of late. Otherwise, they do not have any objection.
For final disposal on 14 September.
14
September.
My lord.
Any other date, madam? I have to come and appear before my lord.
19 September.
Which date?
14th September.
19.
Lordship, can it be 18?
In this.
19th is a hearing day, that is why we have fixed that.
19 is okay.
All right, 21st September.
21st, keep it. Mark.
21st. My lordship, 19,
Then it goes to 26.
19.
19. Ms. Nair, you are here only. Other commitments.
They are.
Then let it go on 26th. 26th September.
Obliged.
Item number 46.
Lord, in this case, my lord, the regulation framed by AERC is under attack, my lord. By that regulation, my lord, it's called, my lord, AERC compensation to victims of electrical accidents regulation. So an amount of rupees 4 lakhs has been fixed for, my lord, loss of life, and another amount for the loss of, for injury, my lord.
Injury.
So my humble submission is that, my lord, this regulation that, my lord, finds at page 50, 49 it starts, my lord. 49 it starts, my lord. It is framed by AERC in exercise of powers conferred under section 181 of the Electricity Act, as well as section 57, page 50. If my lord peruses page 50 for a moment, my lord. Second paragraph, whereas the state commission may make regulations consistent with the act under section 181(1) and notify standards of performance of a license or a class of licenses under section 57 of the Electricity Act. So now if we, my lord, kindly peruse section 57.
You don't want him to argue or what?
As your lordship.
Is he supposed to open the arguments or you are defending even before he opens?
No, my lord, actually he had already concluded, my lord, last.
Yes, ma'am. Regarding compensation.
Anyway, I'll wait, my lord.
Concluded means what? That was on 26th July. It was just an expression that he has argued on basis of this judgment.
Raman.
Let him start, man. Sorry, man.
You, Mr. Das, took instructions, took time to take complete his instructions.
Yes.
I have got the instruction.
You got instructions. What? Are you placing something on recorder?
Yes, sir. I'll file affidavit, madam.
You want to file an affidavit? Mr. Das appearing for the AERC, submit that he has received instructions and would be filing a short affidavit within next 2 weeks. List thereafter.
Otherwise, madam, this case, madam, may fix for hearing of madam. Things has been completed.
List the writ petition for hearing in 3rd week of October.
Obliged, sir.
ले लो hearing item call कर लो. What is it?
Daily list for hearing, item 47.
What is the matter, madam?
POXO matter, Your Lordship.
So,
Only the problem is the victim died.
There has been transfer of IOs.
Okay.
This is the 4th IO, sir. And because of COVID, investigation got bit delayed, sir.
All right.
And we have asked for some documents from the education department. Now we have got the documents, sir.
Okay.
Now, sir, we are doing investigation. I mean, expedited the
So
investigation.
we would just ask you to expedite the investigation and come out with the factual report for perusal of this court. How much time would you require?
Sir, we will submit final form within 1 month, sir.
All right. SP Tinsukia, Mr. So and so is present in the court as per the direction given on 10/8/2023. He explained that the investigation, reinvestigation in the matter was directed in the year 2020
20s.
and thereafter, because of COVID pandemic, the matter got stuck up. However, now relevant documents have been collected from the Education Department and the report under section 173 CRPC shall be filed in the court concerned within next 1 month. That's right.
Yes, my lord.
What is the appeal about?
The appeal is that the documents which we have alleged to be forged were placed before the learned single judge. There was an impersonation in the court of the learned CGM while accepting the final report, and therefore there was an order for payment.
Okay, then we'll consider the appeal once the report is presented. The hearing of this, consideration of this appeal is deferred by 6 weeks, awaiting the outcome of the aforesaid investigation. Copy of the report under section 173 CRPC shall also be forwarded to Mr. R. Mazumdar, Standing Counsel, Education Department, who shall place the same on record by the next date of listing. After providing copy to Learned Counsel to the respondent, re-notify after 8 weeks. Personal presence of SP in Sukhya and the investigating officer is shall not be required for future dates of hearing. On future dates of hearing.
Okay.
Hearing, sir.
Supplementary list, item 48 to 50.
Yes, please.
Yesterday, Lordship, I was placing the act. Now I'd like to place the rules.
Yes.
I would like to place the rules of the state. Then I will take your lordship to the CBSE's bylaws.
Yes. Oh, second file then, rules usme.
Page, it will be page 44 of the writ appeal, Delhi Public School.
Yes.
And also there are certain amendments which have taken place in 2018 regarding the act also. That also the differences I will place, lordship.
Yes.
So these rules came on 16th of October 2017. We find the definitions here, act, which will be the parent act of 2006. Then disciplinary authorities recognition. Prior permission part is there. Application form for prior permission and particulars and information under subsection 1 of section 4. The application for obtaining the prior permission under subsection 1 of section 4 of the act shall be submitted to the director in form 1, furnishing the particulars and information as stipulated in the said form duly filled. The undertaking to be given along with the application for obtaining permission under subsection 1 of section 4 shall be in form IA, which shall be duly signed by the applicants and accompany the application form.
Yes.
So there are 3 stages of a school, how it has to be established. Generally, a new school, first the permission has to be taken. The next stage is registration, recognition, and the third stage is affiliation. Now, registration and administrative recognition. This is what is troubling the writ petitioners here. Form and manner of application for registration in respect of new schools established. Various particulars are to be furnished for registration.
Yes.
The manner and the application fees are quoted. Then regarding the main area of concern is inspection and enquiry. That chapter 4, lordship.
Yes.
Rule 5.1, enquiry and inspection of registration and administrative recognition of existing institutions. After provisional registration of the existing non-government educational institution under subsection 2 of section 6 of the Act, the director shall make or cause to be made an inspection by officers authorized by him
to ascertain the existence of the non-government educational institutions applying for registration, and also to verify the correctness of the particulars and information furnished by the management authority in the application form, including the academic and other facilities provided in the institution. The inspecting officer shall prepare and submit a report in Form 4 for consideration to the director. The director shall place the inspection report before the administrative recognition committee along with other relevant documents for its consideration of administrative recognition and final registration. So the director will not take a call by himself. There is a committee before whom the inspection report will be placed. Now, inspection for the purpose of administrative recognition of institution established with prior permission. The director or his authorized officer may conduct inspection of non-government educational institutions established with prior permission and duly registered for the purpose of administrative recognition as required under subsection 2 of section 5 of the Act and prepare a report in Form 4. The inspection report shall be placed by the director before the administrative recognition committee for its consideration. Then inspection and supervision or inquiry of institution for other occasion. One part is for registration and recognition. The other part is what other situations an inspection can be made. The director or his authorized officer may conduct inspection and supervision or inquiry of non-government educational institution as and when necessary by giving or without giving any prior intimation. General guidelines for inspection and supervision. Normally the inspection and or supervision shall be A and B, Lordship, not the fault finding of teachers and the management, but it should be helpful in the form of concrete suggestions for improvement of teaching, learning process and overall functioning of the institution. B, guide the institution in organization of co-curricular activities and necessary for all-round development. These are very innocuous. I don't think they have any objection. Third part, to ensure implementation and observance of these rules and the provisions of this act in letter and spirit, where they may have an objection. So that part, Lordship, I will deal with his judgment, Lordship. In that case, Lordship, if they are charging exorbitant fees, or if they are diverting the fund of the school for some other purposes, in that situation, this 4th C will come.
Yes.
Regarding the other part, Lordship, other requirements to be fulfilled under subsection 21 of section 10 of the Act, the school hours, vacations, holidays, 3-language formula, maintenance of hostel, etc. Then chapter 6 says about the infrastructure facilities. Coming to chapter 7, meeting of the managing committee and TADA of the members under subsection 5 of section 12 of the Act, meeting and quorum. The composition is already there. TADA of the members, etc., are covered by these rules. Now, the other day I have placed the scheme under section 14. What should be there in the scheme? They have to submit. The scheme of management under section 14 of the Act. Each and every non-government educational institution shall prepare and submit to the director a scheme of management with the following provisions. Power and function of the chairman, secretary, manager, headmaster, or principal of the institution. Procedure to be followed for constitution of the managing committee, powers and functions and tenure of the managing committee. Procedure for selection, appointment and promotion of teaching and non-teaching staff. Qualification of the teaching and non-teaching staff. Salary structure of the teachers and non-teaching staff. Service conditions of the employees, code of conduct for students. Manner of supervision, guidance and control of teaching and non-teaching staff. Students' fee structure. Indicating the rate of admission fees, tuition fees, game fees, library fees, festival fees, development fees, other fees as per student class-wise. Procedure for admission of students and provisions for the concession. This is the core area where the private institutions generally have objections regarding how many students they can admit under management quota, what should be the reservation policy. All these things are main area of dispute.
And the other part, first is a fee structure and the other one is admission. Then K, the manner of collection of voluntary contributions from parents or guardians or others under section 19 of the Act, procedure for taking disciplinary action against students, provisions for professional development of teachers, and lastly, provisions of contributory funds, employees provident fund, welfare schemes for teachers and non-teaching staff. So the scheme must include these parameters.
Yes.
They have to give this scheme to us. We'll verify and finally we'll approve a certain with a certain condition if they need to improve something or if they are not fulfilling the requirements in terms of various Supreme Court judgments, then the director or the committee can interfere. Otherwise, the complete independence is given to the institution. Then Chapter 9, procedure to be followed in disciplinary actions against employees under Section 15(3) of the Act. Further going. Chapter 10, Code of Conduct for Teachers and Other Employees under Section 16 of the Act. Then Chapter 11, Fund of the Institution Maintenance and Accounts and Audit. This I would like to place, Lordship. Rule 6, collection of fees, contribution and other charges. Every fee, contribution or other charge collected from any student by a recognized institution shall be collected in its own name, and a proper receipt shall be granted by the institution for every collection made by it. Maintenance of the school fund. Every fund of the institution shall be kept deposited in a nationalized bank or a scheduled bank or any post office in the name of the institution, and such part of the said fund may be specified by the director or any officer authorized by him in this behalf shall be kept in the form of government securities or in cash in hand respectfully. These are all directly taken from the judgment of TA Pies as well as the Islamic institutions case. These are directly taken from the judgments.
Yes.
Withdrawal from the fund. Withdrawal from the fund shall be made jointly by the head of the institution and chairman or secretary or manager of such institution, or jointly by the head of the institution and by any authorized member of the managing committee where the head of the institution is also manager of the institution. Maintenance of the accounts of the institution. The accounts with regard to the fund of the institution shall be so maintained so as to exhibit clearly the income accruing to the institution by way of fees, fines, income from building rent, interest, development fees, collection of specific purposes, endowments, gifts, voluntary contribution, any voluntary contribution from the People's Fund, and other miscellaneous receipt. Next is utilization of fees realized from the students. Income derived by an institution by way of fees shall be utilized in the first instance for the meeting to pay allowances and other benefits admissible to the employees of the institution, provided that savings, if any, from the fees collected by such institution may be utilized by the managing committee for meeting capital and contingent expenditure of the institution or for any one or more of the following educational purpose: award of scholarship to students, extension of infrastructure, assisting other schools or educational institutions not being in college under the management of the same society or trust by which the first mentioned school is run. The savings referred in sub-rule 1 shall be arrived at after providing the following, namely medical, retirement and other benefits admissible to the employees, needed expansion of the institutions, expansion of construction of the building, co-curricular activities of the students, reasonable reserve not being less than 10% of such savings. All these, although in our rules, it was brought in 2007, in Delhi, it was brought in 1973.
Yes.
And these were all tested in the Supreme Court, these kind of provisions regarding maintenance of the funds.
Yes.
Funds collected for specific purpose like sports, co-curricular activities, subscription for excursions, subscription for magazines and annual charges by whatever name called, shall be spent solely for the exclusive benefit of the students of the concerned institution and shall not be included in the savings referred in sub-rule 2. Collections referred to in sub-rule 3 shall be administered in the same manner as the money standing to the credit of the pupils fund is administered. Then scholarships to student. Then next chapter is regarding the property of non-government educational institution. The list has to be provided. Then reservation of seats for admission of students under subsection 4 and 5 of section 18 of the Act. So various admission procedures and the reservations are given there.
Yes.
So these are basically the provisions in the rules which are supplementing the Act. Now various forms are there. Form 1 is regarding application form for prior permission. What are the things we ask for from them? There are particulars regarding the landed property, the building, everything are included there. And in what level they want the permission to start the school. That is required for new schools.
Yes.
Then Form 1A is undertaking to be submitted along with the application for prior permission under section 4.1 because they get certain time to comply with this also if they get the prior permission. And the final permission is also given thereafter. For that, then application for registration. What exactly we ask for? Because their whole concern is that their own schools, they are not willing to register. What particulars we actually want?
Yes.
Name of the institution, name of individual association or individual society trust establishes the institution. 3, name of manager with address and contact number, full address with PIN code, location, date of establishment. Affiliating body, SEBA, Assam Higher Secondary Education, CBSE, ICSE or others. Then medium of instruction. Number 9, whether existing on the day of commencement of the Act, if yes, please furnish documentary evidence such as purchase of land, building permission. Permission is building permission, electricity bill, etc. 10, whether the institution is established with prior permission from the director after commencement of the Act. If yes, please furnish number and date of such permission. 11, number and date of recognition from the government affiliating body. Documents to be enclosed. 12, level of education imparted, primary, middle, secondary, higher secondary level and classes opened. Then 13, measurement of the plot of land where the institution is located with DAG number, patta number, etc. 14, status of the land, Miyadi, annual patta, etc. Whether the scheme of management as required under section 14 has been prepared, serial number 15. If so, please attach a copy of the same. 16, what is the intake capacity of the institution class-wise, number of students enrolled class-wise for last 3 years. 18, results of the board's final examination. Then 19, total built-up area indicating number of size of classroom, office room, common room, library, science laboratory, storeroom, etc. 12, 20, furniture and equipments available. Then fee structure 22, sanitation and drinking 21, 23 is constitution of the managing committee. Playgrounds and play materials, teaching aids available to the institutions, laboratory facilities, number of library books, fire safety measures available in the institution, facility for co-curricular activities, whether the institution is residential, etc., the status of the school. 31, whether the institution on commercial basis for profit or to any individual or association, there is a specific question, whether it is for profit or it is a charitable organization. 32, whether admission is open to the students irrespective of caste, race, religion, and place of birth, details for teaching and non-teaching staff. So this is basically the requirement for the purpose of registration.
Yes.
For recognition, there has to be an application in a different form at form 3. They are also identical, more or less same informations are sought for. Then form 4 is the form of inspection report. May I place it also?
Yes.
Name of the institution, date of establishment, full address, manager, managing committee, location, market, whether there is any marketplace, shopping complex, cinema hall in the vicinity of the institution, whether the surroundings are suitable for educational institution, whether the school was functioning before commencement of the act, date and number of receiving prior permission, then number and date of receiving the recognition, name of the affiliating body, medium of instruction, level of education being imparted, land, etc., building, furniture, sanitary facilities, safety, fire, teaching aid, library books, enrollment, intake capacity of the institution, teaching and non-teaching staff, teachers people ratio, students fee structure, serial number 28. 29 is curriculum, admission and of students 30, facilities for physical education, facilities for co-curricular activities, academic achievements, school fund 34. Sources of fund, present status of financial condition, maintenance of accounts, audit, etc. Observation of rules and instructions. Whether the management of the institution has implemented and followed the provisions of Assam Non-Government Education Institution Regulations and Management Act 2006 and the rules 2007 thereunder. Whether instructions from the director and the district education authority are followed, if not, please mention in details, etc. Then 36, scheme of management, language and culture, and collection of donation. So this is on these areas, Lordship, the inspection report has to be prepared. Form 5 is the list of movable and immovable properties. Then at page 81, Lordship will find the returns to be submitted by recognized institutions. A copy of the budget estimates showing receipts and payment of ensuing year. Final accounts, receipts and payments accounts, income and expenditure balance sheet of the preceding year, duly audited by chartered accountant. Educational statistics as and when necessary, enrollment of students as on 30th September, pattern of concession, scholarship, etc. Stuff. Now, the area of concern again is, Lordship, that number one, the budget estimate showing receipts and payment of ensuing year. Then number two, the final accounts that are receipts and payments, accounts, income and expenditure and balance sheet. They are concerned with why the director will look into all these things. These are not the creation of the state authority here. There is a direct direction from the Supreme Court that all the accounting should be transparent and fair, so that there is no commercialization, no profiteering. To avoid that, Lordship, and in the Rajasthan unaided schools case, the Honorable Supreme Court very clearly said these institutions are charitable organizations. The business here is totally different from the normal business we understand. If profit is the motive, Lordship, the normal little profit is permissible in a very subtle way, the Honorable Supreme Court has said, but that is not the core intention of any persons establishing this school. And Supreme Court has also said, I'll place all the judgments, Lordship, that if an institution starts its activities of imparting education, and once it transgresses from the changes its position from a charitable institution to a commercial institution, the protection under 19G is not available to them. It will no further be a fundamental right.
Okay. Yes.
So these are the rules and regulations which the state have framed and which is put to challenge.
Yes.
Now, what is there in the affiliation bylaws of 2018 of the CBSC? That they have not produced, so I'd like to place it. They have produced, but they have not placed it. Yes, I have seen the whole video yesterday.
You can keep this one. You can keep this one. Yes.
The CBSC bylaws also contemplate states' control over these institutions.
Yes.
We have two copies, Doctor.
Yes.
Affiliation bylaws. And what is the status of this bylaw, Lordship? The Supreme Court in 2021 judgment very clearly says it is a law under Article 13. There is no, but this is not a state or central legislation.
30 would be for Minority educational institution.
No, 1-3, Lordship.
1-3.
1-3, not 3-0.
Yes. Read which provision?
Yes, the provisions I would like to read. Chapter 1. These bylaws may be called the affiliation bylaws 2018 of CBSE. These shall be effect from the date of notification by the CBSE. Definition: affiliation. Affiliation means formal affiliation of a school with the board for purpose of preparing students for admission to the board's examination. It includes affiliation under all categories and all types. So what they offer, they basically offer the board for the purpose of conducting the examination.
Yes.
The relevant portions I would like to place. Now, Lordship will kindly come to norms of affiliations, chapter 2.
Yes.
Here, essential conditions 2.3. Essential conditions for affiliation of the schools. Any school education institution in India or abroad which fulfills the following essential criteria may apply to the board for affiliation. 2.3.1. Establishment of the school. The school should be established by any one of the following entities: government, statutory bodies, autonomous bodies, local bodies, other government bodies, registered society, registered trust, and company. So these are the categories who can establish these schools. Registration under law. In case of schools mentioned in clause 2. So and so, there should be a properly constituted registered society, registered trust, registered company under section 8 of the Companies Act 2013. 2.3.3 School Management Committee. The subject to relevant provisions of the Education Act rules of the appropriate government. The appropriate government will be Lordship. If it is a school in the state, it is a state government, or if it is central school in Guwahati, it will be a central government.
Yes.
If the Kendriya Vidyalaya, that will be a central government.
Yes.
Or in school which belongs to the state of Assam. But we can also have CBSE's affiliation. Recently, we have opened 10 others of Vidyalaya having CBSE's affiliation.
Right.
We have shifted from SEBA to CBS.
CBS. All
So
right.
in that case, the appropriate government will be the state of Assam.
All right. Yes.
Kendriya Vidyalaya, it will be the central government. Subject to the relevant provisions of the Education Act rules of the appropriate government, every school should have a scheme of management. It should have a school management committee as stipulated in the RTE Act. And as per provisions contained in these bylaws. Recognition from the respective state government. The school seeking affiliation with the board shall submit formal prior recognition certificate from the concerned state education department as per extant rules and provisions contained in the RTE Act 2009. Further, 2.3.5, no objection from the respective state governments. The schools mentioned under clause so and so seeking affiliation with the board shall submit formal prior no objection certificate to the effect that the state government has no objection to the affiliation of the school with CBSE. No objection certificate once issued to any school will be considered at par, even if it is prescribed a specific period and or level unless it is withdrawn.
Yes.
Recognition is now coming to land requirement. Chapter 3.
Yes.
Requirement with respect of land. Here, 3.4 says the land requirement will be minimum 4,000 square meters in case of the following, subject to the restriction of optimum enrollment and number of sections in Appendix 5. Now, 3.4.5 schools located in northeastern region, they have to have 4,000 square meters. So they cannot have any school with affiliation of CBSE if they do not fulfill this criteria. That is for the purpose of affiliation. But for the purpose of recognition, the state rule will cover. And this is, I am sure, Lordship, it is much more than what is we are prescribing in our act.
Yes.
Now, classroom size, physical in chapter 4, the school seeking affiliation must satisfy the following conditions. Classrooms, minimum size should be 8 meters by 6 meters, approximately 500 square feet. Regarding staff, the chapter 5 is there. Appointment orders in the recruitment process, everything is stated here. Basically, the NCT guidelines and NCT norms has to be fulfilled for recruiting the teachers, which we also do.
Yes.
We are not deviating from the norms set by the NCT. Then financial resources, chapter 6.
Yes.
The school must have sufficient financial resources to guarantee its continued existence to meet the running expenditures of the school and to undertake improvement, development of school facilities and capacity building of teachers. No part of income from the institution shall be diverted to any individual in the trust, society, company, school management committee, or to any other person, entity. The saving, if any, after meeting the recurring and non-recurring expenditure and contribution to the developmental, depreciation and contingency fund may be further utilized for promoting the school and extending the cause of education in the same school, which basically we are also doing. We are following the same principle. 6.3, it shall be the responsibility of the school to maintain its account in a transparent and accountable manner. If it's to be kept in a transparent and accountable manner, they should not have any difficulty in showing it to the director. The Supreme Court also says, I'll go to that. But whatever they are doing, Lordship, in 2008 to 18 bylaws, we are exactly doing the same thing, and which are already done by Delhi before the Supreme Court judgment in TMFI and Islamic societies came.
Yes.
In 1973 onwards, this was the position.
Yes.
So it shall be the responsibility of school to maintain its account in a transparent and accountable manner based on accounting standards.
Yes.
The account should be audited and certified by a chartered accountant, and proper account statements should be prepared and maintained as per extant laws rules. All transactions should be made through digital mode. So this is a new edition in 2018. I'm sure in the earlier versions, digital mode was not there because these are recent developments.
Yes.
The school shall separate its account from the society and maintain the books of accounts independently. Now, reserve fund. The school will maintain a reserve fund if the laws, regulations of the appropriate government so stipulates in the manner prescribed under such laws, rules. It shall be the responsibility of the school to maintain a separate register of all the loans taken by the school or by the society, trust, company, from banks, etc., for the school, having complete details of the purpose, securities, and term of repayment, etc., of the loan, and such secured school will ensure that the loan such taken is only utilized for the purpose of for which it is obtained. So the CBSE also is keeping an eye on the financial transaction of the institution.
Yes.
It is not like a common businessman that either the income tax authorities or the ED or the other authorities can look into it. Here, the CBSE is also keeping an eye on their transactions. The whole purpose is to ensure that there is no commercialization of education.
Yes.
It is a noble profession, noble area, occupation, and there is no scope for profiteering here.
Yes.
Now, school fees. Chapter 7. No society, trust, company shall charge capitation fee or accept donations for the purpose of admission for pupils. Admission fee and fee charged under any other head are to be charged only as per the regulations of the appropriate government. Now, what is this appropriate government? In our case, if the school is in Assam and it is not under central government, the appropriate government will be the state government. So the CBSE also visualizes the role of state government. The admission fees and fees charged under any other head are to be charged only as per the regulations of the appropriate government. Fees shall be charged under the heads prescribed by the Department of Education of the state/union territory.
Yes.
So state's role is contemplated under the CBSE bylaws. Now, refund of fees. I'm skipping that. Fees revision. Fees revision of schools shall be subject to laws, regulations, and directions of the appropriate government. Again, the Assam government's role will come if the school is in Assam.
Yes.
Unless it is a central government school. Now, composition of the school management committee. Chapter 8. Subject to relevant provisions in the Education Act of the state unitary concerned,
every affiliated school should have a scheme of management as per following clauses. So here also, they are giving a leeway that the state regulation is there, then that you have to follow that. But ours is much easier than what is contemplated in the CBSE's bylaws.
Yes.
Composition of the school management committee. The management committee of a recognized aided school shall consist of not more than 15 members, and the management committee of a private unaided school shall consist of not more than 21 members. However, in case of senior secondary schools offering vocational subject, additional members, subject experts as per subject offered may be appointed. Subject to provisions of 8.1 and the total number of members specified in 8.2.1, every management committee shall include the following. Number one, the head of the school, she will be a member secretary of the school management committee. Two, parent of students
Yes.
studying in the school, one father and one mother of students specifically in co-ed education schools. Teachers, two teachers of the school, two other persons whom one shall be women, who are or have been teachers of any other school or any college to be nominated by the trust, society or the company. Two members to be nominated by the board. The remaining members to be nominated or elected as the case may be in accordance with the rules and regulations of the society, trust, company running the school.
Yes.
Members may be nominated as per conditions, if any, laid down in no objection certificate. At least 50% of the members should be women. Provided further that the above provisions shall be implemented with immediate effect and the school affiliated earlier and not complying with the above provisions shall be required to take remedial measures with a suitable qualified substitute within a year of notification of these bylaws. Then powers and function of the school management committees. They have to look after the welfare of the teachers, students, etc. Everything is stipulated here. Then role and responsibilities, duties and powers of the important functionaries, society, head of the school, manager, correspondent of the school, etc. Then
10.1.2 recognition or registration data.
Now, chapter 10, procedures relating to submission, processing of applications and approval.
Yes.
This chapter contains various processes, procedures, and provisions relating to applications of various types and actions taken by the board on these applications. Fresh applications and switch over from other boards. Mode of submission of application. All applications shall be submitted online. Applications sent by hand, email, post, or any other means will not be accepted and or processed. The school shall fulfill all the conditions laid down in clause 2.3, subclause 2.3.1, 3.2, 2.3, etc. of these bylaws before submitting the applications for affiliation along with the documentary proof in the prescribed manner. Now, if we look at 2, if Lordship reads 10.1.2
Yes.
with 2.3.4 at page 5
Yes.
of the bylaws. 2.3.4 is recognition from the respective state government.
Yes.
The school seeking affiliation with the board shall submit formal prior recognition certificate from concerned state educational department as per extant rules and provisions contained in the RTA Act of 2009.
Yes.
So while they want to have affiliations under CBSE Lordship, an institution must fulfill all the conditions as laid down in chapter 2, which includes NOC from the state government as well as the recognition certificate from the state government.
All right.
Now coming to inspection of the schools.
Yes.
How the CBSE will do the inspection, whether any prior notice is required or not. All these things are elaborated here. Chapter 11, inspection for affiliation. No school shall be affiliated to the board without inspection by an inspection committee of not less than 2 members, at least one of whom has to be an academician. The following are the broad heads which will be covered during the inspection of the inspection committee. Available infrastructural facilities, actual enrollment of teachers and their qualifications, academic standards, process of teaching in the classes, record keeping, which includes the financial part. 11.1.6, book of accounts, to ensure whether the school is maintaining its accounts separately from the society, trust company running the school. So the book of accounts also can be inspected. Then provisions relating to safety and security of children, implementation of the policy of inclusion in relation to the persons of disabilities, interaction with the members of school management committee, any other areas specifically informed by the board. Now 11.2 speaks about the periodic inspection and inspection for extension of affiliation. So there can be periodic inspection. Now coming to 11.4, surprise inspection.
Yes.
The board may anytime get an affiliated school inspected by a committee of one or more members without giving any notice to the school. So that notice is also not required. So that a sudden visit is permissible. Now 11.5, inspection for special purposes. The board may get an affiliated school inspected by a committee of one or more member to decide on the application of the school received as per the provisions contained in chapter 15 or for any other purpose deemed necessary by the board. Now, who can be the inspection? Inspection committee. 11.7. Inspection of school is a confidential assignment and all information provided to the members is in a fiduciary capacity. The members are required to handle all information with utmost care. 11.7.6. The members are required to ensure that in case of surprise inspection, the schools are not informed about the inspection in advance under any circumstances. Then 11.7.12. Videography is very important aspect of inspection. The member of inspection committee shall ensure that the complete process, including the infrastructure, classroom, laboratories, playgrounds, boundary wall, aerial view are covered in the videography and uploaded, sent in the manner described by the board. It has to be uploaded also, not only recorded. The member shall use utmost care and make recommendations in final report after considering all issues relating to infrastructure, administration, and academics.
Yes.
Now, penalties. Ours is, Lordship, 50,000 was the maximum and 10,000. Here, 12.2 says, if a school is found violating the provisions of the affiliation bylaws, examination bylaws of the board, and does not abide by the directions of the board shall have the power to impose the following penalties. Yes. One is written warning, imposing fine up to 5 lakhs rupees. 11.1.9, withdrawal of affiliation. Then the board, 12.2, the board may impose all or any of the penalties mentioned in 12.1.1 to 12.1.9 to any school in the following cases. For gross malpractices in examination, academics, administration, and financial matters. So financial matters is included here, Lordship. Next, establish no violation, non-compliance of court, central government, state government, or board's directions, instructions. So state government's instruction has to be followed by them. Established violation of, coming to 12.2.5. On withdrawal of recognition by the state government. Suppose they are not fulfilling our terms and conditions, the state government, then if we withdraw their recognition, then the affiliation will also go from CBSC. On withdrawal of no objection certificate issued by the state government, that is also contemplated under the penalties provisions of the CBSC bylaws. On express recommendation order request from the central, state, union territory governments to disaffiliate, shut down the school permanently or impose any other penalty. On a reference request received from the central, state government, etc. So state government can refer that a particular CBSC school is not complying with the terms and conditions of the affiliation as well as other conditions relating to recognition and permission. In that case, the state government can refer it. But while going to that extent, Lordship, the state government has to first do the fact-finding exercise.
Yes.
For that, inspection is required. So inspection is there under the state regulations as well as under the CBSC's regulation also.
Right.
And lastly, for not sending teachers, principals for the teachers training as per requirement of these bylaws. Then procedure regarding imposition of penalties, this principle of natural justice, etc. Then general rules, special provisions, etc. So my humble submission is that, Lordship, this is a bylaw.
Yes.
Which has the status of a law under Article 13. May I please Article 13?
Yes. Please.
Article 13, may I please it? Laws inconsistent with or in derogation of the fundamental right. All laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. The state shall not make any law which takes away or abridges the right conferred by this part, and any law made in contravention of this clause shall, to the extent of contravention, be void. In this article, unless the context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, customs and uses having in the territory of India the force of law. So law will include ordinance. Lordship will kindly note it. Ordinance, order, bylaws, rules, regulations, notification, customs and uses having in the territory of India the force of law.
Yes.
And B says law in force includes law passed by or made by a legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be done in operation either at all or in particular area. Nothing in this act shall apply to any amendment of this constitution or 23068. Now here 3A. There is no mention of act. What is there? It is ordinance, order, bylaw, rule, regulation, notification, customs or uses having in the territory of India the force of law.
Yes.
The force of law under these particular areas, that ordinance, order, bylaws, etc. But it has not included any legislation by either state or by the parliament. Now, what they are trying to emphasize before this honorable court is that we are transgressing the area of the central government by this state act as well as the state rules. And for that, they are harping on the provisions of Article 254(2). Before going to 254, I would like to take your lordship to the chapter, that is chapter 11 of the Constitution.
Yes.
We have to look from the perspective of the chapter, what exactly in the broader way the Constitution contemplates.
Yes.
The mandate is very clear here. Relations between the union and the states, that is the chapter 11. Chapter 1 says in part 11, chapter 1, legislative relations. The whole chapter is on legislation. So it has nothing to do with Rule 13, Article 13. Article 13 starts from ordinance.
Yes.
So 245 says, extent of law made by parliament and by the legislatures of the state. Subject to the provisions of this constitution, parliament may make laws for the whole or any part of the territory of India, and the legislature of a state may make laws for the whole or any part of the state. There are two areas where legislation can be done.
Yes.
245(2). No law made by parliament shall be deemed to be invalid on the ground that it would have extraterritorial operations. Now, 246. Subject matter of laws made by parliament and by the legislature of states, notwithstanding anything in clause 2 and 3. Parliament has exclusive power to make laws with respect to any of the matters enumerated in list 1 in the 7th schedule. That is the union list. 2, notwithstanding anything in clause 3, the parliament and subject to clause 1, the legislature of a state also have power to make laws with respect to any of the matters enumerated in list 3 in the 7th schedule in this constitution referred as concurrent list. 3, subject to clause 1 and 2, the legislature of a state has exclusive power to make laws for such state or any part thereof with respect to any of the matters enumerated in list 2 in the 7th schedule referred as state list. So there are 3 lists: state list, union list, and the concurrent list. And entry 25 comes under concurrent list, which is education. I have already placed that yesterday, subject to entry 63, 64, 65 of and 66 of list 1, which are not troubling the state in drawing up these legislations under entry 25 of the concurrent list.
Yes.
4, Parliament has power to make laws with respect to any or any part of the territory of India not included in a state, notwithstanding the such matters a matter enumerated in the state list. So the Parliament has prevailing power to legislate in case of certain areas where it is in the state list also.
Yes.
246A, that is relating to the GST and Service Tax Act. That was a recent amendment of 2016, if I'm not wrong. Yes, it was of 2016. Then the GST Act came in June 2017.
Yes.
247, power of Parliament to provide for the establishment of certain additional codes. We are not concerned on that now. 248, residuary power of legislation, subject to Article 246A. Parliament has exclusive power to make any laws in respect of any matter not enumerated in the concurrent list or state list. So any residuary item, Lordship, the Parliament has the power. 249, power of Parliament to legislate with respect to matters in the state list in national interest. Very clearly it has been written there. 250, the power of Parliament to legislate with respect to any matter in the state list if proclamation of emergency is in operation. That means when the state is not in functioning, when the emergency is in force. 251, inconsistency between laws made by Parliament under 249 and 250 and laws made by the legislator of state. Nothing in Article 249 and 50 shall restrict the power of the legislature of a state to make any laws which under this constitution it has power to make. But if any provision of a law made by the legislature of a state is repugnant to any provision of law made by the Parliament, which Parliament has under either of the said articles power to make, the law made by the Parliament, which whether passed before or after the law made by the legislature of the state, shall prevail. And the law made by the legislature of the state shall, to the extent of repugnancy, but so long as only as the law made by the Parliament continues to have effect, be inoperative. Very clearly, if state also legislate in the same field, Lordship, the Parliament law will prevail. 252, power of Parliament to legislate for 2 more states, etc., not relevant. 253, legislation for giving effect to international agreements, not relevant at this stage. 254 now. Inconsistency between laws made by Parliament and laws made by the legislature of state. Heading is very important. It is very clearly says, the heading says, inconsistency between laws made by the Parliament and laws made by the state. It is not contemplating any ordinance or law, as we can understand from the mandate of Article 13 of the Constitution of India.
Yes.
So it has to be a law under this chapter, whether it is a state law or a central law. So the heading very clearly says inconsistency between law made by Parliament and laws made by the state legislature. If any provision, 254(1), if any provision of a law made by the legislature of a state is repugnant to any provisions of law made by the Parliament, which the Parliament is competent to enact, or to any provisions of an existing law with respect to one of the matters enumerated in the concurrent list, then, subject to the provisions of clause 2, the law made by the Parliament, whether passed before or after the law made by the legislature of such state, or as the case may be, the existing law shall prevail, and the law made by the Parliament of the state shall, to the extent of the repugnancy, be void. We have no quarrel on that. Now, what they are saying that we should have taken precedential assent. 2, where a law made by the legislature of a state with respect to one of the matters enumerated in concurrent list contains any provisions repugnant to the provisions of the earlier law made by the parliament or an existing law with respect to that matter. To that matter is very critical, Lordship. That means the law made by parliament which is in existence or an earlier parliamentary law. Then the law so made by the legislature of such states shall, if has to be reserved for consideration of the president and has received his assent, prevail in that state.
Lordship,
Yes.
my method is at item 14. So, my lord, it seems that another fixed items are there, may kindly be posted on 26 September, since I come from outside. I have one matter, that CEP matter is hearing on 26 September.
All right, land council. Mr. Your good name, please.
JC Lalnun Sang.
Submits that item number 14.
14.
That he comes from Aizawl.
It's actually Delhi. I am from.
He is
Delhi.
coming from out of station.
Yes.
And as the matter may not be taken up today for positive time, it may be re-notified on 26 September. Advocate General does not object. Yes, Mr. Malhotra, do you have any problem?
No problem, Your Worship. My presence may kindly be marked for respondents 5 and 6.
Okay. Attendance of Mr. Malhotra for response number 5 and 6. May be marked. List on 26 September as per it.
I'm obliged.
Okay, 2000. I would like to start my citations, Lordship. In between, I will place 1, 2 laws also which are relevant and directly in tandem with the Supreme Court's judgments.
Yes.
So first, I would like to know, because they have referred a lot, the TMA Pi Foundation's case, it being a 11 judges constitutional bench, Lordship. So I would like to start from this particular case, 2002 8 SCC, page 481.
Yes.
I'll like to refer to few paragraphs, paragraph 53 to 57, then 64, 66, then 155, and also paragraph 24, because 24 is referred by my learned senior friend, Mr. Nair. So paragraph 24, I'd like to start.
Yes.
Paragraph 24. While the conclusion that occupation comprehends that establishment of educational institution is correct, the proviso in the aforesaid observation to the effect that this is so provided no recognition is sought from the state or affiliation from the university concerned is with utmost respect erroneous. The fundamental right to establish an educational institution cannot be confused with the right to ask for recognition or affiliation. The exercise of a fundamental right may be controlled in a variety of ways. For example, the right to carry on a business does not entail the right to carry on a business at a particular place. The right to carry on a business may be subject to licensing laws, so that a denial of the license prevents a person from carrying on that particular business. The question of whether there is a fundamental right or not cannot be dependent on whether it can be made the subject matter of controls. The established paragraph 25.
Yes.
The establishment and running of an educational institution where a large number of persons are employed as teachers or administrative staff and an activity is carried on, the results in the imparting of knowledge to the students must necessarily be regarded as an occupation, even if there is no element of profit generation. Yes. It is difficult to comprehend that education per se will not fall under any of the four expressions in Article 19(1)(g. Occupation would be an activity of a person undertaken as a means of livelihood or a mission in life. The above quoted observations in Sodan Singh's case correctly interpreted the expression occupation in Article 19(1)(g). 26. The right to establish and maintain educational institution may also be sourced to Article 26A, which grants in positive terms the right to every religious denomination or any sections thereof to establish and maintain institutions for religious charitable purposes, subject to public order, morality, and health. Education is a recognized head of charity. That Lordship may be pleased to know. It is basically a charitable act. In a lot of other cases, there is a repetition of this principle. Therefore, religious denomination or sections thereof, which do not fall within the categories carved out in Article 29, 1 and 30, have the right to establish and maintain religions. This is not relevant for our present purpose. Now coming to paragraph 53. With regard to the core component of the right under Article 19 and 26A, it must be held that while the state has a right to prescribe qualifications necessary for admission, private unaided colleges have the right to admit students of their choice, subject to an objective and rational procedure of selection and compliance with conditions, if any, requiring admission of a small percentage of students belonging to weaker sections of the society, by granting them freeship or scholarship, if not granted by the government. Furthermore, in setting up a reasonable fee structure, the element of profiteering is not at all accepted in Indian conditions. The fee structure must take into consideration the need to generate fund to be utilized for the betterment and growth of the educational institution, the betterment of education in that institution, and to provide facilities for the benefit of the students. In any event, a private institution will have the right to constitute its own governing body, for which qualification may be prescribed by the state or the university concerned. It will, however, be objectionable if the state retains the power to nominate specific individuals in governing bodies. Pausing here for a moment, Lordship. We are not indicating any persons from the state side. Everybody under the rules and the act of the state, the governing body is to be constituted by their own persons. Teachers, principal, chairman, nomination by them. There is not a single person in the managing committee, and this is under the act where the state has any indication or any suggestion. Nomination by the state, which would be on a political basis, will be an inhibiting factor for private enterprises to embark upon the occupation of establishing and administering educational institutions. For the same reasons, nomination of teachers either directly by the department or through a service commission will be an unreasonable inroad and an unreasonable restrictions on the autonomy of the private unaided educational institution. 54. The right to establish an educational institution can be regulated, but such regulatory measures must, in general, be to ensure the maintenance of proper academic standards, atmosphere, and infrastructure, including qualified staff, and the prevention of maladministration by those in charge of management. The fixing of a rigid fee structure dictating the formation and composition of governing body, compulsory nomination of teachers and staff for appointment or nominating students for admission would be unacceptable restrictions. So far as our case is concerned, we are neither interfering with the composition of the management committee, neither we are saying that this should be your fees. You give your scheme, whatever is the fees, we'll verify, and on what principles it has to be verified, that is also there in the act itself. There are certain criteria which has to be looked into by the committee of the state government. Lord. The Constitution recognizes the right of the individual or religious denomination or a religious or linguistic minority to establish an education institution. If aid or financial assistance is not sought, then such institution would be a private unaided institution. Although in Unni Krishnan's case, the court emphasized the important role played by the private unaided institutions and the need for private funding, in the scheme that was framed, restrictions were placed on some of the important ingredients relating to functioning of an educational institution. There can be no doubt in seeking affiliation or recognition. The board or the university or the affiliating or recognizing authority can lay down conditions consistent with the requirement to ensure the excellence of education. It can, for instance, indicate the quality of the teachers by prescribing the minimum qualification they must possess and the courses of study and curricula. It can, for the same reason, also stipulate the existence of infrastructure sufficient for its growth as a prerequisite. But the essence of a private educational institution in the autonomy that institution must have its management and the administration. There necessarily has to be a difference in the administration of private unaided institution and the government aided institution. Whereas in the latter case, the government will have greater say in the administration, including admission and fixing of fees. In the case of private unaided institution, maximum autonomy in the day-to-day administration has to be with the private unaided institution. Bureaucratic or government interference in the administration of such an institution will undermine its independence. While an educational institution is not a business, in order to examine the degree of independence that can be given to a recognized educational institution, like any private entity that does not seek aid or assistance from the government, and that exists by virtue of the fund generated by it, including its loan and borrowing. It is important to note that the essential ingredients of the management of the private institution include recruiting students and staffs and the quantum of fees that is to be charged. An educational institution is established for the purpose of imparting education of the type made available by the institution. Different courses of study are usually taught by teachers who have to be recruited as per the qualifications that may be prescribed. It is no secret that better working conditions will attract better teachers. More amenities will ensure that better students seek admission in that institution. One cannot lose sight of the fact that the providing good amenities to the students in the form of competent teaching faculty and the other infrastructure cost money. It has therefore to be left to the institution, if it chooses not to seek any aid from the government, to determine the scale of fee that it can charge from the student. One also cannot lose sight of the fact that we live in a competitive world today where the professional education is in demand. We have been given to understand that a large number of professional and other institutions have been started by the private parties who do not seek any government aid. In a sense, a prospective student has various options open to him where, therefore, normally economic forces have a role to play. The decision on the fee to be charged must necessarily be left to the private educational institutions that does not seek or is not dependent upon any fund from the government. 57 is very important. We, however, wish to emphasize one point. That is that in as much as the occupation of education is, in a sense, regarded as charitable, the government can provide regulations that will ensure excellence in education while forbidding charging of capitation fees and profiteering by the institution. Since the object of setting up an educational institution is by definition charitable, it is clear that an educational institution cannot charge such a fee as is not required for the purpose of fulfilling that object. To put it differently, in the establishment of an educational institution, the object should not be to make a profit in as much as education is essentially charitable in nature. This is 11 judges' delivery. There can, however, be reasonable revenue surplus. This is what is contemplated there. There can, however, be a reasonable revenue surplus which may be generated by the educational institutions for the purpose of development of education and expansion of the institution.
Yes.
So whatever additional revenue they generate, it has to be invested for the development of the institution and for the purpose of betterment of delivery of education.
Yes.
So it is not like any general business or a normal businessman aspect from his work. Now coming to 64. Paragraph 60 for a moment, Lordship. Education is taught at different levels from primary to professional. It is therefore obvious that government regulations for all level or types of educational institution cannot be identical. so also the extent of control or regulations could be greater vis-a-vis the aided institutions. Now coming to paragraph 64. An educational institution is established only for the purpose of imparting education to the students. In such an institution, it is necessary for all to maintain discipline and abide by the rules and regulations that have lawfully framed. The teachers are also like foster parents and who are required to look after, cultivate and guide the students in their pursuit of education. The teachers and the institutions exist for the students and not vice versa. Once this principle is kept in mind, it must follow that it becomes imperative for the teaching and other staff of an educational institution to perform their duties properly and for the benefit of the students. Where allegations of misconducts are made, it is imperative that a disciplinary inquiry is conducted and that a decision is taken. In case of a private institution, the relationship between the management and the employees is contractual in nature. A teacher, if the contract so provides, can be proceeded against, and the appropriate disciplinary action can be taken if the conduct of the teacher is proved. Considering the nature of the duties and keeping the principle of natural justice in mind, for the purpose of establishing misconduct and taking actions thereon, it is imperative that a fair domestic inquiry is conducted. It is only on this basis, the result of the disciplinary inquiry, that the management will be entitled to take appropriate action. We see no reason why the management of a private unaided educational institution should seek the consent or approval of any governmental authority before taking such action. In ordinary relation of master and servant, governed by the terms of the contract of employment, anyone who is guilty of breach of the terms can be proceeded against and the appropriate relief can be sought. Normally, the aggrieved party would approach a court of law and seek redress. In case of educational institutions, however, we are of the opinion that requiring a teacher or a member of the staff to go to a civil court for the purpose of seeking redress is not in the interest of general education. Disputes between the management and the staff of educational institutions must be decided speedily and without excessive incurring of cost. It would therefore be appropriate that an educational tribunal be set up in each district in a state to enable the aggrieved teacher to file an appeal unless there already exists such an educational tribunal in a state. The object being that the teacher should not suffer through the substantial cost that arise because of the location of the tribunal. If the tribunals are limited in number, they can hold circuit camp sittings in different districts to achieve this objective. Till a specialized tribunal is set up, the right of filing the appeal would lie before the district judge or additional district judge as notified by the government. It will not be necessary for the institutions to get prior permission or ex post facto approval of the government authority while taking disciplinary action against the teachers or any other employee. The state government shall determine, in consultation with the High Court, the judicial forum in which an aggrieved teacher can file appeal against the decision of the management concerning disciplinary action or termination of service. Pausing here for a moment. In 2004 itself, 2002, this judgment was delivered in 2002. This particular Supreme Court bench felt the need of educational tribunal. There are a lot of other areas where this particular case has given the indication, and also the subsequent case which I am going to place next, Lordship. There is a particular way all the states are required to frame certain statutes or law to govern these kind of areas.
Yes.
In Assam also, it was contemplated according to this judgment that there should be educational tribunal. However, we did not do. We did not do. So this act was brought into force, this act, impugned act, in 2011, giving a retrospective effect.
Yes.
From 2012 onwards, there are series of litigations coming before this honorable court under Article 226. One division's view was that writ petition is maintainable. The other division's bench view was that it is not maintainable because these are private institutions and writ will not lie.
Yes.
Whether the contra view was that as they are discharging public function, therefore it is maintainable.
Yes.
So ultimately the matter was referred to the full bench. That full bench judgment I'd like to place.
Sure. And why the state is not contemplating setting up of the tribunals?
we have set up 2016 itself.
In all districts?
Yes, all districts.
Okay. They are functional?
They are fully vibrant.
Okay.
And a lot of cases are coming to this honorable court from the tribunal.
That's right. Right.
These are all the transitory things. These are certain things which was not contemplated in 2001. Gradually, things are moving.
Okay.
So this is reported in 2015 to GLT, page 337.
Yes.
Full bench. Abdul Ghaffur Mandal versus State of Assam.
Yes.
3 writ petitions, Lordship, paragraph 5, 3 different issues. Paragraph 5. In WPC, so-and-so was filed asserting that in various inspection reports, the petitioner was shown as assistant teachers of the school. The inspection reports all were prepared by the district authority, district elementary education officers. So that is one area of dispute. The other dispute is, Lordship, paragraph 6. WPC so-and-so was filed by petitioner alleging despite interim order dated so-and-so, respondent had not forwarded names of so-and-so as for provincialization. This is 2. Then 3rd, there is another case. All these 3 cases and the Honorable Learned Single just felt that there is a conflict. Paragraph 9.
Yes.
From perusal of the order dated 18 to 2014 of the Learned Single Judge, it is evident that a preliminary objection was raised with regard to the maintainability of the writ petition. The Learned Single Judge noticed 3 judgments of this court, namely judgment in WA Muhammad Haider Ali, judgment of Anupam Sinha, and judgment of Vishnuram Das,
Yes.
taking 2 different views with regard to the issue of maintainability of the writ petition. While in Ali Haider, the division bench held that the writ petition was not maintainable against a venture school. In Anupam Sinha, a division bench of this court took a contra view, holding that said judgment is in conflict with the judgment of the apex court in so-and-so, 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 and followed Vishnuram Das. The Learned Single Judge noted that there is no dispute that the part of the school in question is a venture school, which is defined under 2S of the Act of 2011. This is a provincialization act. As it is a primary school imparting education up to class 5 and was established prior to 1/1/2006 by the people of the locality and not provincialized under any act enacted by the state legislature till then. By the order dated 18 to 2014, the Learned Single Judge opined that the conflict of decisions need to be first heard, resolved by a larger bench once for all, and consistency and clarity of the order placing for matter before the Learned Chief Justice. So the full bench was constituted. Now coming to, there's a discussion of the 2011 Act and as well as 2006 Act. 2006 Act, Lordship will kindly come to paragraph 35. The Act which is under challenge in the present proceedings, Lordship.
Yes.
The Act of 2006 centers around regulations and management of non-government educational institutions as the preamble of the Act. 2006 goes to show that 2G of the Act of 2006 defines non-government educational institutions to mean schools or junior colleges established and run by an individual or association of individuals or any non-government organization or society trust, except the school established and mandated by maintained by minorities under clause 1 of Article 30 of the Constitution and imparting education at primary, middle, secondary, and higher secondary level without receiving any grant in aid from the state government, excluding the educational institutions run or aided by the central government or the state government. The statement of objection and reasons of the 2006 shows that it had become necessary to enact a law to regulate unplanned and mushroom growth of non-government educational institutions. It also noted that there is an increasing trend towards commercialization of education and that many institutions have been established with the sole motive of earning profit. It is also observed that teaching and non-teaching staff is paid meager salary and their services are terminated on flimsy.
These are all provisions of the Act have been replaced.
Yes, Lordship.
Come to the ratio.
Yes, now ratio, paragraph 44.
44 again, reproduction of the Act.
Reproduction, that is a civil court's bar. That is also the Honorable Court noted it.
Noted is all right. There's no issue about that. Noting is just the reproduction of the Act.
Paragraph 45. From the reading of 2006 Act and 2007 rules, it became evident that though a non-government educational institution is purely a private institution, it is statutorily regulated. Being a purely private body, judicial intervention in exercise of power of judicial review may not be available in the internal matters of the institution. such as disputes relating to appointment, seniority, decision of the managing committee, etc. It is difficult, nay, impossible to catalog situations where writ remedy may be available. As discussed earlier, we may indicate that such a remedy will be available where there is a violation of statutory provisions or where decision of a non-government educational institution affects public interest. We have noted that in matters relating to discipline and imposition of penalty, the employees are entitled to procedural safeguards which are statutorily recognized. If one is aggrieved by any imposition of penalty prescribed, he may appeal to the appropriate court. That is also in the rules, that provision is there in our rules. Though
In
court
which-
is not defined.
Which rules?
In our rules, that rules I'll list. Rule 17.4. 17.4 of the 2007 rules.
Yes.
17.4. Appeal. In 3 places, appropriate court is referred. Site as others. Where a penalty or dismissal, removal or termination from service imposed on an employee, it is set aside and rendered void, the consequence of by a decision of the competent court. Such employees shall be deemed to have been placed under suspension by the managing committee from the date of origin. So there is indication of courts in the rules in several places that is referred, but no court is defined.
While excluding the jurisdiction of a civil
court.
Now you read para 45.
Yes. now
What we
I'm-
observed yesterday
Yes.
is reflected in the full bench's view.
Yes, full bench
Yes.
very clearly, ultimately, full bench directed for constitution of the educational tribunals.
Yes.
It is difficult to, near impossible to catalog situations where writ remedy may be available. As discussed earlier, we may indicate that such a remedy will be available where there is a violation of statutory provisions or where decision of a non-government educational institutions affects public interest. We have noted that in matters relating to discipline and imposition of penalty, the employees are entitled to procedural safeguard which are statutorily recognized. If one is aggrieved by any imposition of penalty prescribed, he may appeal to the appropriate court, though the court is not defined, and at the same time recourse to civil court is barred. In such a situation, perforce a writ petition may have to be entertained as no person can be left without any remedy. The issue raised may also involve disputed question of facts, which Lordship was indicating yesterday. The disputed question of facts, the writ court will not enter. It is well known that
Ultimately, this judgment just gives a direction to establish the tribunal.
we have established.
There is no discussion regarding validity of the provisions.
No. What I'm saying, so this issue that there is no remedy in the act, that has been already, remedy has taken place.
It's like, if you recollect yesterday, what we were indicating when you just fired off was that there have been many changes. This act was stayed by this court for, it has remained suspended animation for 11 years. In the meantime, there have been many developments. Your act doesn't countenance the provisions of the Persons with Disabilities Act, which have to be incorporated therein. It doesn't give any indication regarding, just hold on please. No, indication regarding remedial measures available to the guardians if so required. Where do they go? Supposing they are aggrieved by the decision of the managing committee.
or the school institution, school management? Where do they go? What is the remedial measure provided in your act? Is it indicated? Now you have established those tribunals, but those tribunals, do they entertain the disputes raised by the guardians if so required? That is why we suggested yesterday that now this is almost a stale law in view of RT, in view of the cap on fees under the direction of the Supreme Court. Many changes are required. These are transient provisions, as you yourself said. So a better act with proper provisions that is required.
Lordship, my humble submission is very clear.
Yes.
Whether there is any unconstitutionality in the law.
All right, that we will decide.
Yes,
Then
because they have challenged.
The-
They have not come here
all right,
for
then you carry on.
giving some amendments to the act.
Carry on,
They
carry
want that the whole act should go. There is a difference.
That is for the
Whatever
court
Lordship has,
test.
whatever
Mr.
has fallen
Saikia,
from Lordship's mouth, that is a different area.
that is
In the judgment,
for the
Lordship
court
can
to test which of the provisions are constitutional, which are not, or which violate the fundamental rights of the institution, or for that matter, the parents or the teachers for that matter. So those provisions, particular provisions, if over a period of time, certain statutes have come in, it is for the state to look in. Further, the bigger reason is that for 12 years, the state has had no interest whatsoever in getting revival of this law.
No,
This was lying state, Ms. Saikia, we are telling you. This was
This is
state,
the fourth time I am arguing this matter.
we don't know. We don't know.
It
We
is.
don't know. The order sheets do not reveal.
That may not be revealed, but it was argued before my Lord Justice Ajit Singh when he was the Chief Justice here. Then it was my Lord Justice Bopanna. Then my Lord Justice Chief Justice
Saikia,
Dhuli.
WC 2806.
It
we will
has
just
been
tell you,
argued. In
just
fact, the other day, my
hold on.
learned senior friend submitted.
Hold on. WPC 2806. It was listed lastly on 30th March 20. Just hold on, please now. Before that, it was listed on 22nd February 2016. For 4 good years, it was never listed. And earlier there too, it was in 2015. Parties are directed to maintain status quo. That's all. After that, 2806 doesn't indicate a single hearing. That's what the order sheets reveal. So that's why we suggested that now much water has flown. Probably the state would itself like to have a look.
If Lordship gives those observations in the judgment, we'll definitely look into it. But the thing is that what they are challenging, whether we
Mr.
have,
Saikia,
we have done
the
anything
litigants obviously come to this court by exaggerated challenges, but it's not necessary that every challenge has to be accepted.
So we do not know what will be the outcome. So
All right.
that we have to defend first.
Okay, very well.
Because we do not know the judgment beforehand.
Okay, very well. Carry on then. Continue. Yes, continue.
Yes, I'm continuing, Lord.
Yes.
Now I'd like to place those notifications. If Lordship is having the same book, page 1.
Page 1.
Page 1. Elementary, this is a notification of 2nd June 2016 regarding function of educational tribunals. In inviting a reference to the above, I am directed to inform you. The very first page, Lord.
Yes, yes.
Regarding function of educational tribunals, in inviting a reference to the subject above, I am directed to inform you that the government notification dated 3/12/2015 designated the Court of District Judges and additional district judges of each district to function as educational tribunals to adjudicate disputes of teaching and non-teaching staff of non-government educational institutions, as well as disputes relating to disciplinary action and claims for provincialization, will be applicable in case of secondary and higher educations. Also, from the date of publication of the above notification, a copy of the notification is enclosed here. And there is another notification for other districts at the next page of 2015. So that remedialess issue that civil courts are barred because the Everything is the offshoot of the TMA PI's case.
This remedy is only available to the teachers and the staff. What about the institution?
No, institution is there, the provincialization part.
The institution is aggrieved by the
Yes.
decision of the.
Yes, that is why this Supreme Court here says, paragraph 64,
Yes.
that where there is a statutory norm. Yes. Last four lines of that paragraph.
Yes.
Till a specialized tribunal is set up, right of filing appeal would be before the district judge or additional district judge as notified. It will not be necessary for the institution to grant prior permission or ex post facto approval of the government authority while disciplinary action against a teacher or other. If the state government shall determine in consultation with the High Court, the judicial forum in aggrieved teachers can file appeals, so and so, so and so. Just one line was there. I'll just come back to it.
Take your time.
Yeah, 64 first line, Lordship. An educational institution is established only for the purpose of imparting education to the students. In such an institution, it is necessary to maintain discipline and abide by the rules and regulations that have been lawfully framed. So this Act of 2006 is the statute.
Okay.
So that is a statute.
Very good.
Really, And thereafter, the amendment of 2018, 28A. Let us go there, Lordship.
Yes.
28A.
Page. Is it there in this book?
It is in, it is there.
Page. 595.
28A, appeal. Any non-government educational institution or individual, non-government organization, society or trust, as the case may be, establishing any non-government educational institution, aggrieved by the order of the director, passed under any of the provisions of this act, may prefer an appeal before the state government against the order of the director within 30 days from the date of receipt of such order. Decision of the state government in such appeal shall be final and binding on all concerned. Definitely, Lordship, thereafter the writ court door will open.
Yes.
So they are not remediless. So when we say that section 27, except as expressly provided in this act, no decision or order made in this exercise of any power conferred by or under the provision shall be questioned in any civil court. So all the provisions in which the director or any authority may pass an order are appealable orders.
Right. Yes. Okay.
So the institution has a remedy through the appeal before the state government, and the remaining parts like the employees, the teacher, they can go to the educational tribunal.
Yes. Okay.
Now coming to this judgment, TMFI, it has been further explained. in the case of 2003 6 SCC, page 449.
Yes.
Islamic Societies case. Volume 6 SCC, page 697. It's a 5 judges constitution bench.
Yes.
Paragraph 1 onwards.
Yes.
On 31/10/2002, an 11-judge bench of this court delivered the judgment in TMA Prize Foundation case. A brief history as to how an 11-judge bench of this court came to decide this case is set out in paragraph 3 of the judgment, which is read as unders. So I'm not on that. Paragraph 2, most of the petitioners applicants before us are unaided professional educational institutions, both minority and non-minority. On behalf of petitioners applicant, it was submitted that answers given to the questions as set out at the end of the majority judgment laid down the true ratio of the judgment. It was submitted that an observation made in the body of the judgment had to be read in context with the answers given. We are unable to accept this submission. The answer to the questions in the majority judgment in Pi's case were merely brief summation of the ratio laid down in the judgment. The ratio decidendi of a judgment has to be found out only on reading the entire judgment. In fact, the ratio of the judgment is what is set out in the judgment itself. The answer to the question would necessarily have to be read in the context of what is set out in the judgment and not in isolation. In case of any doubt as regard to any observations, reason, or principles, the other part of the judgment has to be looked into. By reading a line here and there from the judgment, one cannot find out the entire ratio decidendi of the judgment. We therefore, while giving our clarifications, are disposed to look into other parts of the judgment other than the portions which may be relied upon. So the submissions are recorded. Paragraph 5 now. Both the sides relied upon various passages of the majority judgment in support of their respective submissions. These passages are reproduced below. In view of the rival submissions, the following questions arise for consideration. 1, whether the educational institutions are entitled to fix their own fee structure. 2, whether minority and non-minority education institutions stand on the same footing and have the same rights. 3, whether private unaided professional colleges are entitled to fill up their seats to the extent of 100%, and if not, to what extent. 4, whether private unaided professional colleges are entitled to admit students by evolving their own method of admission. Now, question 1, answer paragraph 7. So far as the first question is concerned, in our view, the majority judgment is very clear. There can be no fixing of any rigid fee structure by the government. Each institute must have the freedom to fix its own fee structure, taking into consideration the need to generate funds to run the institution and provide facilities necessary for the benefit of the students. They must also be able to generate surplus, which must be used for the betterment and growth of the educational institutions. In paragraph 56 of the judgment, it has been categorically laid down that the decision on the fees to be charged must necessarily be left up to the private educational institutions that do not seek and what are not dependent upon any fund from the government. Each institution will be entitled to have its own fee structure. The fee structure for each institution must be fixed in mind, keeping in mind the infrastructure and facilities available, investment made, salaries to be paid to the teachers and staff, future plans for expansion or betterment of the institution. Of course, there can be no profiteering and capitation fees can be charged. It does need to be emphasized that as per the majority judgment, imparting of education is essentially charitable in nature. Thus, the surplus profit that can be generated must only for the benefit and use of the educational institution. Profit surplus cannot be diverted to any other use or purpose and cannot be used for personal gain or for any other business or enterprise. As at present, there are statutes, regulations which govern the fixation of fees, and as this court has not yet considered validity of those statutes, regulations, we direct that in order to give effect to the judgment of TMFI, the respective states governments concerned shall set up in each state a committee headed by a retired High Court judge who shall be nominated by the Chief Justice of that state. The other members shall be nominated by the judge, should be chartered accountant of repute, a representative of the Medical Council of India or the All India Council of Technical Education, depending on the type of institutions, shall also be a member. The secretary to the government of state government in charge of medical education or technical education, as the case may be, shall be a member and secretary of the committee. The committee should be free to nominate co-op another independent person of repute so that the total number of members of the committee shall not exceed 5. Each educational institution must place before the committee, well in advance of the academic year, its proposed fee structure. Along with the proposed fee structure, all relevant documents and book of accounts must also be produced before the committee for their scrutiny. The committee shall then decide whether the fees proposed by that institute are justified and are not profiteering and charging capitation fees. The committee will be at liberty to approve the fee structure or to propose some other fees which can be charged by the institute. The fees fixed by the committee shall be binding for a period of 3 years, at the end of which period the institute would be at liberty to apply for revision. Once fees are fixed by the committee, the institute cannot charge either directly or indirectly any other amount over and above the amount fees fixed as fees. If any other amount is charged under any other head or guise, example donation, the same would amount to charging of capitation fee. The government appropriate authorities should consider framing appropriate regulations. This is precisely what has been done here, like in all other states.
Read the entire line.
The government appropriate authorities should consider framing appropriate regulations if not already framed, whereunder it is found that an institution is charging capitation fees or profiteering, that institution can be appropriately penalized and face the prospect of losing recognition and affiliation.
This is only for the purpose of capitation fees or profiteering. It's a limited purpose. Otherwise, for fixation of the fee, the committee has to be added by a retired High Court judge.
Yes, Lordship.
So whether we have a committee here?
Yes.
Okay.
We have a committee here.
And then if that committee is doing that,
Yes.
discharging that
My Lord
function.
Justice Anima Hazarika was the head of that committee till 3 months ago. Now a new, their tenure
New
is just
committee is
over.
there. All right.
Yes.
Yes.
It must be mentioned that during arguments, it was pointed to us that some education institutions are collecting in advance the fees for the entire course for all the years. It was submitted that this was done because the institute was not sure whether the student would leave the institute midstream. It was submitted that if the students left the course in midstream, then for the remaining years, the seat would lie vacant and institute would suffer. In our view, an education institution can only charge prescribed fee for 1 semester/year. If an institution feels that any particular students may leave in the midstream at the highest, it may require that the students to give a bond/bank guarantee that the balance fee for the whole course would be received by the institute, even if the student left in the midstream. If any education institution has collected fees in advance, only the fees of that semester can be used by the institutions. The balance fees must be kept invested in fixed deposit in a nationalized bank. As and when fees fall due for a semester year, only the fees falling due for the semester can be withdrawn by the institution. The rest must continue to remain deposited till such time till they fall due. At the end of the course, the interest earned on those deposits must be paid to the student from whom the fees was collected in advance. Now, paragraph 20. Our directions for setting up 2 sets of committee in the states has been passed under Article 142 of the Constitution of India, which shall remain in force till appropriate legislation is enacted by the Parliament. Till now, Lordship, the Parliament is silent on the higher education and secondary education. Only in medical education and only in technical education, there are legislation. So in that view of the matter, there is no question of any repugnancy of the state act with the central act. And that judgment also I will place, Lordship, Mahatma Gandhi's institute. The expenses incurred for setting up of such committees shall be borne by each state. The infrastructural need and provisions for allowance and remuneration of the chairman and other members of the committee shall also be borne by the respective state governments. Now I'm coming to paragraph 24. Introductory remark of my Lord Justice S.B. Sinha. Imparting education is a state function. The state, however, having regard to its financial and other constraint, is not always in a position to perform its duties. The function of imparting education has been, to a large extent, taken over by the citizens themselves. Some do it for pure charity, some do it for protection of their minority status, whether based on religion or language, and some do it by way of their occupation. Such institutions are aided by the state and some are unaided. Privately managed educational institutions imparting professional education in the field of medicine, dentistry, engineering have spurted in the last few years.
These are dealing with the professional education.
No,
There is
however,
colleges.
I'm coming to the middle portion. However, whatever I'm reading, Lord, it has some relevance to our case. I've gone through the whole judgment and very few lines I'm reading, Lord. However, the fundamental right of a citizen to establish an educational institution and in particular professional institution is not absolute. These rights are subject to regulations and laws imposing reasonable restrictions. Such reasonable restrictions in the public interest can be imposed under clause 6 of Article 19, regulation and regulation 30 of the Constitution, that is for minority. The right to establish an education institution, although guaranteed under the Constitution, recognition and affiliation is not. These are two different aspects, Lordship. Right to establishment is one thing. But to get recognition, for that recognition, Lordship, we want their registration. In fact, that is not fundamental right. They can establish it. They can run the educational institute. They can impart education, but the students, if they have to appear to some board for examination, then recognition is required, then affiliation is required. Otherwise, with permission, if it is a higher secondary level school, they can run it. For elementary school level, without permission, they can establish the school if the local people wants it, or if a particular individual wants it. But their students cannot appear in the board examination. For board examination, they have to take help of some other institutions who has affiliation. So their school students will go to some other schools to appear in the examinations.
Yes.
So right to establishing a school is different from right to get recognition and affiliation.
Yes.
So this line is important. The right to establish an educational institution, although guaranteed under the Constitution, recognition or affiliation is not. Recognition or affiliation of professional institution must be in terms of the statute. Like other schools also, not only professional institutions, any school. In the case of the schools in concern in the present litigation, they have to have the affiliations from SEBA and CBSE, and CBSE wants that they must have the recognition from the state government. I placed it this morning, Lordship.
Okay. Very well.
26. Entry 66 of list 1 and entry 25 of list 3 of the 7th schedule of the Constitution of India provide for legislative field in this behalf. We are legislating under entry 25. Various states have enacted laws for regulating admission and prohibiting charging of capitation fees. Said legislations also provide for employment of teachers, their conditions of service, discipline in institutions, and several other matters. Such regulatory measures have been subject matter of various decisions of this court. Now coming to paragraph 147. Regarding fee structure. On a bare reading of the relevant paragraphs of the judgment, that is TA5 Foundation's case, some of which are referred to herein before, it is beyond any doubt that in the matter of determination of the fee structure, the unaided institutions exercise greater autonomy. They, like any other citizen, carry on an occupation must be held to be entitled to a reasonable surplus for development of education and expansion of the institution. Reasonable surplus doctrine can be given effect to only if the institution makes profits out of their investment. As stated in paragraph 56, economic forces have a role to play. Thus, they indisputably have to plan their investment and expenditure in such a manner that they may generate some amount of profit. What is forbidden is capitation fee and profiteering. There is one other judgment which explains profiteering. I'll take that judgment also. 148. However, the different state governments have prescribed different amounts by way of fees, as would appear from the following: Andhra Pradesh, etc. Now, 149. The expression capitation fees does not have any fixed meaning. The legislature of some of the states, however, have defined capitation fees. We may notice that Tamil Nadu Education Institution Prohibition of Collection of Capitation Fee Act 1992, capitation fee has been defined as: capitation fee means any amount by whatever name called, paid or collected directly or indirectly in excess of the fees prescribed under Section 4. Section 4 of the Act says regulation of fee, etc. Notwithstanding anything contained in any other law for the time being in force, the government may by notification regulate the tuition fee or any other fee deposit that may be received or collected by the educational institution or class or classes of such educational institution in respect of any or all classes of students. 151. Once, however, it is held that such a provision would not constitute a reasonable restriction within the meaning of clause 6 of Article 19, it must also be held that such a provision would not satisfy the test of permissible regulations within the meaning of Article 30 thereof. Now coming to paragraph 154. The fee structure does its relation to each and every college must determine separately, keeping in view of several factors, including facilities available, infrastructure made available, age of the institution, investment, future plan for expansion, betterment of educational standard, etc. The case of each institution in this behalf is required to be considered by the appropriate committee. That management plan under Section 14 takes into consideration this aspect, Lordship. They have to give the fee structure also, and the committee will verify. CBSE also have the same scope of work under their bylaws. The State Act has also had the same scope. For the said purpose, even the books of accounts maintained by the institutions may have to be looked into. That is the role of the inspection. So book of accounts is nothing to be hidden, Lordship. It should be very transparent and it should be very fair and properly maintained through a chartered accountant. Whatever is determined by the committee by way of fee structure have regard to the relevant factors, some of which are enumerated herein before. The management of the institution would be not entitled to charge anything more. While determining the fee structure, safeguard has to be provided so that professional institutions do not become auction houses for the purpose of selling seats. Having regard to the statement of law laid down in the paragraph 56 of the judgment, it would have been better if sufficient guidelines could have been provided for. Such a task, which is difficult one, has to be left to the committee. While fixing the fee structure, the committee shall look into consideration inter alia the salary or remuneration paid to the members of the faculty and other staff, the investment made by them, the infrastructure provided, and the plan for future development of the institutions, as also expansion of the educational institution. Future planning or invest in an expensive device for medical college or powerful computer for technical college. These factors are also required to be taken care of. The state must evolve a detailed procedure for constitution and smooth functioning of the committee. Our act has that. I will list that act also a little bit later. What are the areas the committee will look into while determining whether that fee structure is reasonable or not reasonable? 56. While this court has not laid down any fixed guidelines as regard to fee structure, in my opinion, one of the honorable judges' opinion, reasonable surplus should ordinarily vary from 6 to 15%. As such surplus would be utilized for expansion of the system and development of education. So it is not for personal profit of the trust or the body. It is only for the purpose of development of education and the institution. The institution shall charge fees only for 1 year in accordance with the rules and shall not charge fee for the entire course. Profiteering has been defined in Black Laws Dictionary. Taking advantage of unusual or exceptional circumstances to make excessive profit. So the Honorable Judge indicated that 6 to 15% is reasonable. But if you take the situation that at the time of admission, if the parents are fleeced for the sake of a seat for their wards, that will become profiteering, and it is to the effect that they are taking advantage of an unusual or exceptional, or it will be just like a situation where they can call the shots.
Yes.
Unequal bargaining. So that is what is the Honorable Supreme Court tries to check. 159. With a view to ensure that an educational institution is kept within its bound and does not indulge in profiteering or otherwise exploiting its students financially, it will be open to the statutory authorities. So in our case, the director is the statutory authority. And in their absence by the state to constitute an appropriate body till appropriate statutory regulations are made in that behalf.
Right.
So this is what was contemplated by this judgment of 2003. That all the states must have a proper mechanism, proper authorities who can monitor all these things in the unaided education institution, so that there is no capitation fees charged, no profiteering, no commercialism of education.
Yes.
The objective is very sacrosanct. The respective institutions, however, for the aforementioned purpose must file an appropriate application before the committee and it places all documents and book of accounts in support of its case. So in everywhere, Lordship, the book of accounts, they have to divulge. They cannot hide the book of accounts. 161. Fees once fixed should not ordinarily be changed for a period of 3 years unless there exists an ordinary circumstances. The proposed fees before indication in the prospectus issued for admission have to be approved by the concerned authority body set up. For this purpose, the application should not be filed later than April of the preceding year of the relevant education session. The authority body shall take the decision as regard fees chargeable latest by October of the year concerned, so that it can form part of their prospectus. No institution should charge any fees beyond the amount fixed, and fees charged shall be deposited in a nationalized bank. The Supreme Court is very clear about that. In several occasions, they have said the money should be deposited in nationalized banks. And CBSE said all forms of transactions should be in digital mode. In other words, no employees or any other persons employed by the management shall be entitled to take fees in cash from the students concerned directly. The statutory authority may consider the desirability of framing an appropriate regulation inter alia to the effect that in the event it is found that the management of a private unaided professional institution has accepted any amount other than the fees prescribed by the committee, it may have to pay penalty 10 to 15 times the amount so collected, and in suitable cases, it may lose its recognition or affiliation. The Supreme Court also indirectly says that there is a chance of closure of your institution.
Yes.
162. However, there cannot be any doubt that before any such order is passed, the institution concerned shall be entitled to an opportunity of being heard. Our act also fulfills this requirement, that their proper opportunity of being heard is provided.
Yes.
For the aforementioned purpose, the state shall set up a machinery to detect cases where amount in excess of the permitted limits are collected, as it is in general experience that students pay a huge fund. So the Supreme Court directed that state shall set up a machinery.
Yes.
Their concern is that why the director is given so much of power, unfettered power. It cannot be said unfettered power. He has a particular set of norms where he can look into the affairs of the school. He cannot go beyond the norms which is there in the statute or in the rules. So the Supreme Court's direct, the state shall set up a machinery to detect cases where amount in excess of the permitted limits are collected, as it's a general experience that the students pay a huge amount. However, if for some reasons fees have been collected for a longer period, the amount so collected shall be kept in fixed deposit in a nationalized bank against which no loan or advance may be granted, so that the interest accrued thereupon may ensure to inure to the benefit of the student concerned. Ordinarily, however, the management should insist for a bond from the concerned students. So regarding seats and all, paragraph 164 onwards, they have not agitated regarding the admission process, so I'm not skipping this. One 187.
They're all for professional courses.
Professional courses, Lord.
Come to page 193.
Yes,
There are 190
here also, Lordship, the Honorable Supreme Court says last line,
Yes.
the relevant enactments wherein these statutory authorities have been created provide for such law. However, assuming such a machinery has not evolved, the state may constitute a body which may be headed by a person who has been a judge of a high court,
Yes.
to be nominated by the chief justice thereof. Standard of education at no cost shall be given a go by. So far the central legislation is basically relating to medical education and technical education.
Medical.
Other general educations, there is no board.
The committee is to be constituted of a retired high court.
Lordship.
Yes. Yes.
Now, paragraph 130, 159, 153, 115. Few paragraphs are on interpretation of judgment 139 to 143. I'm not reading it. Your Lordship may just keep a note. 139 to 143. I would like to take your Lordships to page paragraph 221. There's an epilogue in this judgment, which in my view, Lordship, it is little bit relevant in our case. An epilogue. It is unfortunate that a constitution bench has to be constituted for interpreting a 11-judge bench judgment. Probably in judicial history of India, this has been done for the first time. It is equally unfortunate that all of us cannot agree on all the points, despite the fact that the matter involves construction of a judgment. In the name of interpretation, we have to some extent, however little it may be rewritten the judgment. We have laid down new law and issued directions purported to be in the terms of Article 142 of the Constitution. We have interpreted TMA, but we have also made endeavors to give effect to it. In some areas, it was possible. In some areas, it was not. We have refrained ourselves from expressing our opinion at this stage as to whether grant of settlement of government land at the throw of, I'm skipping this, not three, paragraph 223. The superior courts in India exist for interpretation of the Constitution or interpretation of statutes. There cannot evolve a foolproof system on the basis of affidavits filed by the parties or upon hearing their counsel. Certain details of vexing problems on the basis of interpretation given by this court must be undertaken by the statutory bodies which have requisite expertise. It is expected that statutory bodies would be able to perform their duties for which they have been established. The doors of the court should not be knocked every time if a problem arises in implementation of the judgment, however slight it may be. The court has own limitations. The problem which can be sorted out at the ground level by holding consultations should not be allowed to be brought to the court. It is in that view of the matter, we have thought it is fit to direct setting up of committees for the aforementioned purposes. This committee's Lordship, of course, director is the one of the part of that committee's Lordship. It is not that he will take some actions and he will, if he does something wrong, he will go scot-free. He is also answerable. He has a service career. The person who is holding the post of director, he's a senior ACS officer or an IS officer. The way they are saying that a director will take full control of the institution, it is absolutely unfounded, baseless, Lordship. That thing is not there. Whatever he has to do, there is a committee itself, and everybody is.
They have not commented on the functioning of the committee or the powers of the committee. They have made no comment at all.
But directors.
And a committee headed by a retired high court judge, yes, of course, that committee will be sacrosanct. There is no dispute about that.
there can be no question.
Even
And that
after,
committee is constituted in light of the Supreme Court judgment. So there is no question, there is nobody to question the validity
Yes.
thereof.
their question
For
is the
that there is-
director.
Yes.
Now, director's case, I'll come now.
Come to that.
Yes.
All right.
All the states, it is the director who is heading this kind of committees or this kind of function.
Yes.
Delhi's act,
Let's see the Delhi's act please.
I'll come, Lordship, paragraph 225.
Of this very judgment.
I'll place, Lordship.
The same judgment you are continuing.
No. Yes.
225.
225.
Yes.
We have come across several schemes framed by the states in terms of whatever incentives are being given to the private industries for generating employment or reduction in taxes as proposed if graduates are employed. The respective states therefore must apply their mind while granting essentiality certificate in as much as the human resource development problem will be faced by. In evolving a sound policy decision in this behalf, the statutory bodies shall have to be lend their ears to the respective state governments while granting permission for establishment of a
Professional institutions.
the human resource development.
This deals with
Ministry.
professional institutions.
Yes, Lordship. Now,
We are not
if-
talking of professional institutions here. There's
here,
a different category
ultimately,
entirely.
the professional institutions are also covered.
They are entirely different category. For them, the logic, rational laws, they are entirely different. They are under a very, very more, very higher stringent
Yes.
scrutiny.
Yes.
There on the.
Now, Lordship,
Yes.
there is an institution imparting law, education in law. Whether that will come under professional education, because some of the institutions, they give law
They have-
education here.
They
also.
have their own system, like, Bar
Lordship.
Council of India is there.
Now
Yes.
coming to this judgment.
Which one? Which one?
Yes, I'm coming, Lordship. Yes, 2009,
Then.
10 SCC. 2009, 10 SCC, page 1. Action Committee of Unaided Private Schools versus Director of Education, Delhi. There is a direct attack on him in this case.
Let's see.
I'd like to, very short judgment, not very long. So relevant paragraphs I'd like to read out.
Just.
It's a 3 judges bench. 1 judge was dissenting, 2 judges concurring. So I'm reading the concurring judgment. Page 5. By these review petitions under Order 40 Rule 2 of the Supreme Court Rules 1966, read with Article 137 of the Constitution of India, the petitioner, Action Committee Unaided Private Schools, seeks review of the judgment of so-and-so. On 8/9/1997, a public interest litigation was filed in Delhi High Court by Delhi Abhibhavak Mahasangh Parents Association, being petition so-and-so. Paragraph 3. It may be noted that the order dated 10/9/1997, Director of Education found that in some cases surplus money was transferred to parent societies and other schools in violation of Rule 177. According to Director of Education, directed that fees and funds collected from the parents be utilized in accordance with the Rule 177. Rule 172, 75, 76, 177 of the Delhi Education Rules 1973 are quoted below.
Okay.
Trust or society not to collect fees, etc. Schools to grant receipts to fees, etc. collected by it. No fees, contribution or other charges shall be collected from any students by the trust or society running any recognized schools, whether aided or not. Every free, contribution or other charge collected by any students by a recognized school, whether aided or not, shall be collected in its own name and proper receipt shall be granted. 175. Accounts of the school, how to be maintained. The accounts of with regard to the school's fund or the recognized unaided school fund, as the case may be, shall be maintained to exhibit clearly the income accruing to the schools by way of fees, fines, income from building rents, interest, development fund, collection for specific purposes, endowments, gifts, donations, contributions to people's fund, and other miscellaneous receipts, and also in case of aided school, the aid received from the administrator. 176. Collections for specific purpose to be spent for that purpose. Income derived from the collections from specific purposes shall be spent only for such purpose. 177. The fees realized by unaided recognized school, how to be utilized. Income derived by an unaided recognized school by way of fees shall be utilized in the first instance for meeting the pay, allowances, and other benefits admissible to the employees of the school, provided that savings, if any, from the fees collected by such schools may be utilized by the managing committee for meeting capital or contingent expenditure of the school, or for any one or more of the following educational purposes, award, etc., up to ABC 3, then 2. The savings referred in sub rule 1 shall be arrived at after providing the following, namely pension, gratuity, other specific retirement, and other benefits admissible to the employees of the school. B, needed expansion of the school or any expenditure of developmental nature. C, expansion of the school building or the expansion of the construction of the building. D, co-curricular activities. E, reasonable reserve fund not being less than 10% of such savings. Fund collected for specific purpose like sports, curricular activities, subscription for excursion or subscription for magazines, and annual charges by whatever name called shall be spent solely for the exclusive benefit of the students of the concerned school and shall not be included in the savings referred to in sub-rule 2. The collection referred to in sub-rule 3 shall be administered in the same manner as the monies standing to the credit of the pupils' fund are administered. Directive dated 10/9/1997 in this regard is issued. F, fees and funds collected from the parents shall be utilized strictly in accordance with Rule 177 of the rules. No amount whatsoever shall be transferred from the recognized unaided school fund to a school of the school to the society or trust as the case may be running that school, nor shall be expenditure to be incurred which is not beneficial to the students or employees of that school. On 30/10/1998, both the petitions referred to herein above were disposed of by a common judgment of the Delhi High Court in Delhi so and so. Relevant paragraphs from the judgment of Delhi High Court read as follows. The background under which the impugn orders were issued as discernible from government files may now be noticed. It seems that the government received complaints from number of public schools had arbitrarily increased fees and other charges without any justification. A special committee was constituted to conduct special inspection mainly to examine the justification of increasing fees. The inspection was restricted to few prominent schools. To carry out the inspection, 5 different teams comprising officers of the Directorate of Education were constituted to look into the matter of accounts and also examine whether fees charge is commensurate with the facilities provided to the students and teachers. The inspection team were required to examine 5 years accounts and examine amounts received from students as fees, other charges under each head, including donations, security, building fund, activity fees, laboratory fees, games fees, horse riding fees, etc. Besides transportation, bus charges, and amounts actually spent under specified heads. The committee was also required to examine if there was any surplus under any head and how the surplus money was used. The financial transactions between the school management and the society were also required to be checked. The inspection of 16 schools was conducted. From a perusal of the inspection report, the government found gross financial mismanagement and violation of various provisions of the Act and rules, and observed that almost all the schools were charging exorbitant admission fees, caution money, tuition fees, and other charges under various heads in violation of Section 18(4)(b) of the Act, read with Rule 176. The government also observed that by charging the exorbitant amounts, schools had generated large amount of surplus fund, and in some of the cases, it was found that the surplus money had been transferred to the parent society in violation of Rule 177. Some of the managing committee of the schools had transferred the school fund for establishing the school even outside Delhi. Utilization of the fund was not found to be in the manner prescribed in Rule 177. It was found that the schools were spending money in purchasing and maintaining luxury cars, etc., which were not useful and necessary for the benefit of the students. It was observed that the financial irregularities had been noticed in all schools which were inspected under Section 24(2) of the Act, and the possibility of such irregularities by other unaided recognized schools could not be ruled out. Noticing that the Directorate of Education does not have sufficient infrastructure to carry out special inspection of about 800 such schools, the general direction in public notice was decided to be issued. This is the background under which the impugned order 10/9/97 was issued. Now, Rule 177 is quoted here, Lordship. Again. Then paragraph 36, internal paragraph of that judgment. Now, coming to
36. Para 36 of this judgment.
yes, para 36.
This would not be relevant because it's a
It is not relevant.
dissenting view by a single judge.
Coming to next,
by
the
one of the
paragraph
judges.
54. Next, in the same page 9, assuming power to regulate can be inferred from section 24.
Page.
The same page 9. Page 9.
Paragraph.
It is below, it is second paragraph. So it is a quoting of the judgment, paragraph.
Yes.
Quoting of the judgment of 1992, 3 SCC, page 390, MCD versus Children's Book. Assuming power to regulate fees can be inferred from section 24. A bare perusal of the section shows that it does not confer any special general power on the Director of Education. Reading of subsection 3 and 4 of the section 24 shows that only specific direction in respect of a particular school in which a defect or deficiency may be found at the time of inspection or otherwise alone can be issued. On failure to comply with any directions given under subsection 3, the Director of Education, as contemplated by subsection 4, can take suitable action, including withdrawal of recognition. It was contended that assuming section 24 can be applied, 16 schools on inspection of which alleged defects and deficiencies were found, then action against only those schools after following the procedure laid down in the Act and rules could alone be taken. We may also take note that another rule which shows that if any school indulges in commercialization of education, the Director of Education is not powerless to take appropriate action. Rule 50 of the chapter 4 provides a conditions for recognition of private schools. Under the said rule, a recognized school has to continue to follow the conditions specified in the rules. Sub-rule Roman 4 of Rule 50 provides that the school is not to run for profit up to any individual, group or association or individuals or any other person. If the Director of Education finds that the school is being run for profit, such a school would be violating a condition of recognition, and thus it can be said to rectify its failing, which to face the consequences which may be withdrawn of recognition as a result of not continuing to fulfill the condition of recognition. The Director of Education would be justified in asking the school to explain facts, which according to the Director of Elementary, Director of Education may show that the school is not being run for profit. The school is obliged to explain facts to the satisfaction of the Director of Education. So the Director is empowered under this Act. So we are doing the same thing.
Okay.
If it is unable to do so, the Director of Elementary can ask the school to reduce the fees and other charges which according to the Director show that the school is indulging in profit motives. In our view, it would not be open to the school to say that a Director has no power to direct the school to reduce the fee and other charges, as no such power vested in respect of unaided schools because of section 17(1) and 2 of the Act applies only to aided schools. The direction to reduce fee and charges is to avoid straightaway taking away the extreme step of withdrawal of recognition or taking over the school. It is an opportunity given to the school so that the Director of Education may not resort to withdrawal of recognition or steps for taking over the management are not taken. It only amounts of granting an additional opportunity to the school so that on compliance of the extreme action of withdrawal of recognition or taking over the management, etc., may be avoided. But for the findings and the recommendation of Raghavan's committee, which makes present case a quite peculiar to which we will advert a little later, we find force in the submission in section 24 and rule are applicable to specific schools, which may be found to be violating these provisions. Despite these conclusions, we feel that problem here is peculiar, which necessary issue of general order, which per se cannot be held illegal in facts and circumstances. Paragraph 62. In so and so, the question that came up for consideration before the Supreme Court was whether section 8(4) of the Delhi School Education Act, which inter alia provides that no employee shall be suspended without the approval of the Director of Elementary, would be applicable to the minority institutions. The case of minority institution is that it is encroached upon their right under Article 30 of the Constitution. Relying upon the decision of Frank Anthony, the Supreme Court held that the endeavor of the court in all cases has been to strike a balance between the constitutional application to protect what is secure to the employee under Article 13 and the social necessity to protect the members of the staff against arbitrariness and victimization. It is accordingly held that Section 8(4) cannot be said to have encroached upon the right of the minorities under Article 14. So the director's approval is also required if any adverse action is taken to be taken in a minority institution against their employees.
Yes.
The role of director is important, Lordship.
Okay.
In view of the aforesaid discussion, our conclusion may be summarized. It is the obligation of the administrator and or director of education to prevent commercialization and exploitation in private unaided schools, including schools run by minorities. No permission from director of education is necessary before or after fixing tuition fees. In case, however, such fixing is found to be irrational and arbitrary, there are ample powers under the Act and rules to issue directions to school to rectify it before resorting to harsh measures. The question of commercialization of education and exploitation of parents by individual schools can be authoritatively determined on thorough examination of accounts and other records of each school. The Act and rules prohibit transfer of funds from the school to the society or from one school to another. Going further, Lordship, here. Then there's a discussion on dual committees. I am not on those. Paragraph 15. When the matter reached final hearing, 3 points were argued. The said 3 points are quoted herein below. Whether the Director of Education has the authority to regulate the quantum of fees charged by unaided schools under Section 17(3) of the Delhi School Education Act 1973. The other questions are not relevant. 16. Now, in the review petition, we are mainly concerned with first 2 points. The second point is regarding Lordship. May I just read B? Whether the direction issued on 15/12/1999 by the Director under Section 24(3) of the Delhi School Education Act 1973, stating inter alia that no fees, funds collected from parents, students shall be transferred from the recognized unaided school fund to the society or trust or any other institution is in conflict with Rule 177 of the Delhi School Education Rules 1973. These are the questions basically answered. In the review petition, we are mainly concerned with the first 2 points. It may be noted that the judgment under review was delivered by this court on 27/4/2004. At that point of time, this court in TMA Pi versus and State of Karnataka for Islamic Academy, both judgments I have cited place, held the field. Therefore, this court was required to decide the question of reasonable fee structure and the autonomy of the institution, transparency and accountability in the context of the judgment in TMA Pi Islamic Academy. The majority view in the present case finds place in paragraph 17, 18, 21, and 23 of modern schools case. I'll come to that judgment tomorrow, Lordship. Analyzing Rule 172, 175, 176, and 177, this court in modern schools case held that application of income was not equal to income. The majority view was that there was a difference between appropriation of income and transfer of fund. It was further held by the majority that under Clause 8 of the Order of Director of Education, dated 15/12/1999, the management was restrained from transferring fund to the society or the trust or any other institution. Whereas Rule 177 Sub-Rule 1 refers to appropriation of income from revenue accounts for meeting capital expenditure of the school, and therefore there was no conflict between Rule 117 and Clause 8 of the order issued by the Director of Education, dated 15/12/1999. Via paragraph 27, this court gave further direction to the Director of Education in following terms. In addition to the directions given by the Director of Education, dated to 15/12, we give further directions as mentioned herein above. Every recognized unaided school covered by the Act shall maintain accounts on the principles of accounting applicable to non-business organization, not-for-profit organizations. This is Supreme Court direction in modern school. In this connection, we inter alia direct every such school to prepare their financial statement consisting of balance sheets, profit and loss accounts, receipts and payment account. B, every school is required to file statement of fees every year before the ensuing academic session under section 17(3) of the said with the director. So all these acts covers that there is a specific role of the director. Such statements will indicate estimated income of the school derived from fees, estimated current operational expenses towards salaries and allowances payable to employees in terms of Rule 177(1). Such estimate will also indicate provision for donation, gratuity, reserve fund, and other items under Rule 177 sub-rule 2 and savings thereafter, if any, in terms of the proviso to Rule 177(1). It shall be the duty of the director to ascertain whether the terms of allotment of the land of the government to the school have been complied with. We have shown a sample letters. This is regarding allotment. Now coming to paragraph 18. On 5/7/2004, the present review petitions came to be filed, basically challenging the majority view holding that Director of Education has the power to regulate the fee structure of private unaided schools, including utilization of fund under Rule 177(1)(b)(c). According to the review petitioners, in the matter of fees fixation, since there are statutory rules governing the fees, no direction could have been issued by this court governing the no directions could have been issued by this court contrary thereto. According to the review petitioners, the direction issued by DOE dated 15/12/1999 were neither the subject matter of the writ petition before the High Court nor were subject matter of the special leave petition. According to the review petitioners, the order of DOE dated so and so was not the subject matter of the civil. Notices were issued of the review by dated so and so. Now coming to paragraph 21. There is merit in the argument on behalf of the Action Committee management. The 1973 Act and the rules framed thereunder cannot come in the way of management to establish more schools. So long as there is a reasonable fee structure in existence, and so long there is a transfer of fund from one institution of the other under the same management, there cannot be any objection from the Director of Education. In the review petition, it is alleged that clause 8 of the order of DOE dated so was never challenged, and yet the court has gone into the validity. There is no merit in this argument. It is argued on behalf of the management before us that clause 8 of the order of DOE dated so and so goes beyond 170, and therefore the court has discussed in the judgment under review paragraph 21 the difference between actual and application of income. In the review petition, it was further pleaded that where the 1973 Act and the rules thereunder operate, regulations of education would be governed thereby, and therefore the court cannot impose any other or further restrictions by traveling beyond the scope, object, and purport thereof. In this context, it may be noted that TMA Pi Foundation and Islamic Academy of Education, the principle of fixing fee structure has been illustrated. However, they were not exhaustive. They did not deal with determination of surplus and appropriation of savings. In fact, in the majority view of the present matter, this court has found that in the above topics are not dealt with by the 1973 rules, and therefore clause 8 was found not to be beyond 177, Rule 177, or in conflict thereto as alleged. The additional direction given in the judgment of the majority by paragraph 27 in modern school do not go beyond Rule 177, but they are a part of a gap-filling exercise and discipline to be followed by the management. For example, every school shall prepare balance sheet and profit and loss account. Such conditions do not supplant Rule 177. If reasonable fee structure is the test, then transparency and accountability are equally important. If reasonable fee structure is the test, then transparency and accountability are equally important. In fact, as can be seen from reports of Duggal Committee and earlier committee, excessive fees stood charged in some cases despite the 1973 rules because proper accounting discipline was not provided in 1973 rules. Therefore, the further direction given are merely gap fillers. Ultimately, Rule 177(6) transparency and accountability and further directions in Rule paragraph 27 merely brings about transparency. Lastly, it may be noted that the matter has come up to the apex court from public litigation, hence there is no merit in the above plea. Subject. So the Honorable Court has taken note of what are the powers under the rules and all these acts give power to the director. But director is not the authority to fix the fee structure. His role is that when a fee structure has been approved, the school authorities must follow that. If there is any deviation, then his role comes. That is one aspect. If the surplus fund is diverted other than for the purpose of expansion of the institution or for betterment of the education system in that institution, he can interfere.
Yes.
There are certain situations when he has a role to play. Otherwise, generally speaking, Lordship, the giving the form in form 4 of the rules. These are formalities. What is asked for? Give the name of the school, all the particulars, what is the fee structure, etc. Scheme of the things. And the scheme of the things is not he is the sole authority to examine. There is a committee. And there is a process how that fee structure has to be looked into. What are the parameters? In what categories the fees can be structured? What should be the quantum? What is the size of the institution, number of students, the facilities available?
Yes.
How much you are paying to your teachers? Various factors have to be looked into. Then only a scheme is to be approved.
Yes.
And once that is approved, you cannot deviate from it. And the Supreme Court has also said that if the fee structure is fixed, it has to be for 3 years, unless there is a extraordinary circumstances when you can
change it.
Revise it.
Okay. Yes.
So the role of the director is very much specific. He cannot act arbitrarily. And if there is any arbitrary action on his part, definitely. When the school is doing arbitrary action, then the director will have to step in. And if the director does the same thing, then the appeal is there because the government will look into it because the school has the authority. They have empowered under the provisions of appeal 28A that they can file appeal. And the state government is also not following the due process of law or there is any incorrect or wrong order. Then this honorable court is there. So it is not that they are remediless. So if I'm allowed to stop today and continue.
Sure. Arguments continue. Let's go for the hearing tomorrow. Arguments by Advocate General Mr. Saika continue, but could not be concluded. List for the hearing tomorrow.
Deeply obliged.
हटा दीजिए कल लगाता है तो ये उसी में डाल फाइल में कॉल कर लीजिए ना बिकॉज पीपल माइट बी वेटिंग फॉर दैट
Top of the list matters. Item number 2.
Yes. Is there anyone there? Item number 2.
Lordship, my senior is coming.
Okay.
M.
Pass it.
Bhagavati.
Item number 3.
Last matter was called out. Non-present. List October date dीजिए. In October. Date October में दो third week, second week, third week. Yes. Next.
Item number 4.
In which matter?
My lord, lordship directed requested the additional advocate general to prepare a chart, my lord.
In which one?
That APSC matter, item number three.
Three, yes. Whether Mr. Mazumdar, you prepared that? Can you share it with the council?
There.
Share the chart. You have a copy? Extra copies are there?
Yes. These are.
Let's see. You'll have to provide it to Mr. Chaudhary and Ms.
Yes,
Das also.
I have extra copy.
Yes.
And on the first two pages,
Yes.
I have given the discrepancies that.
Yes, you could notice.
Yes.
Apparent discrepancies. Yes.
That we will go later on. Lordship will kindly go to the Roman page.
Page
4 first.
Four.
One. This is the distribution of marks
Yes.
by the APSC. They have decided that for HSLC, they will give 12 marks.
12, yes.
For HSLC, that is higher secondary,
Ten.
they'll give 10. This way, this distribution is there.
Bachelor 20.
Then next page, Lordship will kindly see 14 persons who were ultimately recommended.
Yes.
Then
Failed.
yes,
Failed, and then the marks were changed and then they were passed.
my lord.
What happened?
Lordship will kindly be with you for a moment. These 14
Yes.
candidates were recommended. Next
Recommended, what is the meaning of F in the remarks column? F, female. Female.
Gender.
Yes, yes.
Next page, Lordship will find the merit list. The merit list contains the marks which they have been given.
Yes.
On the extreme right hand side column, that marks are there.
80.
Yes.
Yes.
Now, thereafter, Lordship will kindly go to the page Roman 8. That
Yes.
also is again a same list as in
SES.
yes. Now, Lordship will kindly see the mark sheet thereafter.
Yes, yes.
Serially. Now, straightway, Lordship may kindly go to the page number 2, serial number 4 on the left hand side.
Yes. Dhruv Jyoti Chaudhary.
Dhruv Jyoti Chaudhary. Now, right as so Lordship goes to the column serial number 11.
20 has been cut and 11 has,
Yes.
17 has been given.
In fact, when it
75 was cut and 70 was given.
Yes. Now here, Lordship will kindly see there is an initial, but this 20 also possibly it was initially 20, then it was made 22, then ultimately 17. And in the total, grand total, there is a difference of 5 marks. From 75, it has been brought down to 70.
Oh.
So this way I have found now instead of going there, Lordship may come to the first page now.
Yes, yes. You prepared a
Yes,
consolidated chart.
Yes.
Yes.
This serial number is in the merit list, left hand side, extreme left hand side. Name is Naina
So
Bhuya.
despite deductions, she continues to be in the merit list.
Yes. Now, right, extreme right hand side column, Lordship will kindly see the remarks. I
Deducted
agree.
2 marks in general bearing.
Deducted 2 marks, then
Yes.
next one added 2 marks, then overwriting in general bearing. It's not very clear, but then 4th one overwriting, 5th one deducted 3 marks in general bearing. At the end, my love, of this 3-page synopsis, I have mentioned most of the corrections were made in general bearing marks of the candidates.
General bearing, what does it connote?
My lord, it is for the APSC to clarify. I am not very sure what.
100 marks, 50 marks for academic qualification, 30 marks is general bearing. Because accepted by the
General bearing means viva voce or what? Viva voce. Okay.
the end of member of family. Another 20 marks is the end of subject expert.
Right.
There was a daring, and daring was converted to marks.
So there has been the cuttings are all in general bearing.
It's the only possible way.
And my lord, the name of the appellant finds place at page Roman 2, serial number 23. Second page, my lord.
23, yes.
4 marks were deducted.
So if 4 marks were retained, would she stand in merit?
My lord, that is for them, my lord, to APSC again.
Let's see the merit list. The names recommended.
Yes.
That list is there.
Go to serial, page 223.
14 posts are there.
Yes.
So this candidate is in general category?
Shahnaz will be general.
Shehnaz in general. So general category. Yes, merit is 70. 69. She has been brought down to 69
Yes.
by reduction of 4 marks.
Yes.
Yes. And that criminal case, it has not had any effect on this recruitment in general.
Possibly directly there is nothing possibly, man.
Because there are other recruitments which have been totally.
This
Only one
person who took interview and the person who gave telephone call, he is from soil conservator, and the person who took interview is from APSC member. In similar case, my lord, APSC, my lord, the charge sheet has been filed. I've given it a page.
No, that's, we are not going into the fact of the charge sheet.
My submission.
Because in this case, the charge sheet has still not been
filed, but in similar cases, my lord, where the
Yes, Mr. Muzumdar, what do you, what?
My submission will be, so far as that part is concerned, man, the criminal investigation as such has got no direct bearing.
No direct bearing on
Unless
this.
we have specifically that so much of money was given,
Yes.
this was done.
But then, what is the reason for deduction of marks?
Well, that it's for the APSC.
Yes, APSC.
I have only done it for your lordships, man.
Yes, we understand. We appreciate it.
Can I just make one?
You represent whom?
I represent the candidates, my lord, the private selected candidates.
Those who have been selected.
My lord, out of the 14 candidates, Lordship may kindly take note, 9 selected candidates are there whose marks were deducted. Only in respect of 2, the mark was enhanced.
Yes.
And no change.
Who are those 2?
Yes. Serial number, my lord, in the list given by my learned friend, Mr. Mozumdar, my lord. Serial number 4, 2 and 4, my lord.
Added 2 marks.
2 and 4. So 9 selected, their marks were reduced. 2 enhanced, 2 no change, 1 not very clear. Because my junior had the, my lord, occasion to go through the records, my lord. He has taken note of that. So out of 14 selected, 9 candidates were selected, their marks were reduced. 2 candidates whose marks were enhanced. 2 no
Ms.
change.
Chaudhary, Deep Jyoti Sharma.
Yes.
68 to 75.
Yes.
Direct beneficiary.
Maybe, my lord.
So, Masjidul Islam addition or subtraction would not have made any difference because on even on 74,
yes,
would have
you
been
have
selected.
got it. Yes.
So the direct impact is on Deep Jyoti Sharma.
Yes, could be. My lord, that view lordships will take. But my humble submission is, my lord, this addition or deduction was in respect of almost everyone, it looks like, my lord.
What is the
So
rationale?
therefore, to say them.
What is the rationale behind it?
No, my lord, that my lord.
And the general conduct of the person concerned is writ large from the record. He is facing trial in more than one cases. One of the trials is almost to conclude. He remained in custody for years together, we suppose.
My lord will kindly, my only submission would be, my lord.
Yes.
Unless and until, my lord, we can connect this so-called wrongdoing with giving them some benefit, my lord, perhaps lordships will not jump to that conclusion. My lord, there is nothing to suggest that this was done only to, bring somebody.
Increase of 7 marks, Mr. Chaudhary, by deduction. Increase of 7 marks by overwriting.
No, I'm saying also then in case of 9, it was deducted. Here they were saying.
Maybe. There might have been something going on, but 7 is a stark figure.
Only in case of 2, it was increased.
Out of the total marks of general bearing are 30.
30.
So 25% increase by cutting.
No, other than Dibjyoti Sharma, as your lordship has rightly said, Majidul even by 74, you would have got it.
Yes.
So it could not have any material effect.
Yes. So material effect is only on
Dibjyoti.
Deep
Yes. Otherwise, my lord, by and large, my lord, 9 who were selected, their marks were in fact reduced. In case of 2, there was no change. Whatever was there is there.
Yes.
And in case of 1, it is not clear. So that is the position, my lord. So therefore, my lord, unless, my lord, one can connect these, unlawful act with the, benefit.
Can we overlook the conduct of that person? You tell us the justification.
No.
An increase of 7 marks in general bearing. At what point of time it was done? Because that person is obviously not before us. What is the stand of the APSC in this regard? Have you filed an affidavit?
Lordship, I have prepared one chart, Lordship. If
Lordship, allow me to place, Lordship.
Yes.
It is on the basis of that cutting and alteration. Lordship, if Lordship, the first candidate, who is Lordship put by.
That is what the chart Mr. Mazumdar has prepared, same thing.
It defines Lordship. Lordship, kindly see, Dhurubajyoti Chaudhary, he is at CL number 4 of that mark sheet, Lordship. His initial mark was 75.
He got reduced to 70.
Reduced. Otherwise, if he had that 5 mark was not reduced, he would have been selected as a candidate, Lordship.
But Dhurubajyoti has otherwise been selected or
No,
not?
Lordship, not selected.
No, but he is not before this court.
Not before this court.
Okay.
And next, Imdadul Islam Khan. He originally he got 75 marks. There was 2 alterations. Firstly to 72 and next 70, 5 marks were reduced, not selected, Lordship. And third candidate, Indu Bhushan Datta. He alteration from 75 to 70, 5 marks reduced, and he is thereby selected as a OBC candidate. Otherwise, he would have been selected as a general candidate, Lordship. Next, same also Nilutpal Pal also, Lordship. He was selected as a OBC candidate. 2 marks has been reduced.
Are there allegations of fraud and fabrication against this BK Dole also?
Yes, Lordship.
He is also in the same boat.
Same boat. He was also arrested, Lordship. Now, Lordship, in that cell number 70, Lordship, Chen has become a petitioner, Lordship. Lordship, 73 mark was awarded initially, and 4 marks were reduced. Had these 4 marks were not reduced, he would have been selected, Lordship, because the last category candidate, Jyoti Shikha Das, he secured 71 marks and selected. Otherwise, Shenaz Begum would have been selected, Lordship. Female candidate, Lordship. And 72 is another Begum female candidate was selected. Had this 73 was originally kept intact, he would have been selected. And the same thing, Lordship. On about that, it has no bearing. Only 1 mark it was. He was otherwise selected, Lordship. He being a SC candidate. Now in Deepjyoti Sharma, total 7 mark was enhanced, Lordship. It was by Akash Kumar Pal interview, Lordship. Otherwise, he would not have been selected because his mark was 68 and a cutoff will be far below than cutoff mark.
Yes.
This was, Lordship, marks I have given how that alteration was and manipulation was done, Lordship. And if, Lordship, proper actual marks secured by the candidate were put in a merit list, entire merit list would have been changed.
Entire merit list.
Merit list would have been
First
changed.
marks initially granted.
Granted, Lordship.
If they are kept in mind, then the entire merit list would be changed.
Lordship. If Lordship allow me, I can place that actual merit list as per their original mark, Lordship, with the help of APSC officials, Lordship. If Lordship,
That is all right. The question here is, gentlemen, when was this cutting made? When was this cutting made? What is the time? If it was made subsequently, after the expert had given the marks, and the mark sheet was initially filled in.
Lordship, in this process, Lordship, expert getting in the expert getting sheet, Lordship. And getting was converted.
That was collated by the chairperson.
Yeah, there is no, Lordship, cut or alteration in expert, Lordship.
In expert's report.
Subjection. But everything was done in case of 30 marks given by the chairman or member, Lordship.
Whether this cutting is there in the evaluation sheet also?
There was no, as per my, Lordship, information.
There's no evaluation sheet of the chairperson.
Only one, Shamidur Rahman maintained only evaluation sheet, and there was also cutting, Lordship.
In that. So if there is a cutting in the evaluation sheet, yes, that can be explained. That right at the time of the interview, it was considered that no, this should be the marks. But in the final collation,
that's it.
The chart which is prepared, if there are cuttings in that, that creates the suspicion.
That's it.
So can you make a statement whether there was any evaluation sheet at the time when the interview was held? And these chairpersons, did they prepare the evaluation sheet?
I took that instruction also that except the evaluation sheet of the general bidding sheet of one member, Shamidur Rahman, others has not maintained.
Not prepared.
Not prepared, Lordship.
How did they fill these marks?
Actually, that was the procedure. They had to took some rough, and after calculation, there is a chance of this manipulation.
Yes, Mr. Das.
That is
What
when
is
the telephone call comes in.
Telephone call, at what point of time did you
that is
state about the telephone call.
Hello.
When did you raise that issue?
Hello, we raised it long time, after considerable time. But the question is, my lord, the lordship knows, my lord, what goes on.
You can't take judicial
And
notice.
this cutting many things your lordship has
Cuttings,
said.
you see, had it been an isolated case, it's a different thing. Then if we are to go by the cuttings, the entire result is changed.
Yes.
The other candidates are not party before this court. Then
Other candidates, all the candidates are there. Person
all
who-
selected candidates are there.
All are there. APSC, my lord, your lordship, at one period of time, they are in a, only recently things have, improved.
How many were the posts at place?
14, my lord.
14. This list only shows 12 selected.
I think, no, I think this list may not be that correct.
Yes, lordship.
No, there's one list at serial number 8, Mr. Mazumdar is placed. That is 14 selected.
No, lordship, other two, there is no alteration or cutting, lordship of mark.
In respect of two, there was no change.
No changes, lordship.
No change, that is why he is not.
This I have not. This is only in respect of that candidate.
No change in respect of Jutika Da
Mm.
and Jyoti Majumdar. No, not sorry. No, 1 second. No change, no change.
There is.
That one STP, STH category, Kareng Bepi
Mm.
and my lord Jyoti Sikha Das. In their case, my lord, there is no alter.
Mm. Mr. Das, if the same logic is applied, Richa Napen, she also gets in. She also secures, she had only at 72 marks.
Yes, ma'am.
So she also gets in. There's a complete reshuffling because last candidate selected in the general category secured how many marks?
Lordship, last category.
General category.
Jyoti Sharma 75.
Nazia Hassan, no.
Nadia Hassan.
My lord, your lordship, in my submission would be
71.
Lordship,
let them reconduct the examination again from the interview.
What about these candidates? They are serving since when?
They are not serving.
no serving.
No one is serving as yet.
Government has not given a
Allotted
poll.
also.
We are posted,
Hmm.
but my lord, we are not allowed to join.
They were not allowed to join. Mr. Chaudhary, then the reasonable thing is to hold a fresh interview.
Kindly take a call.
How-
regard to-
How to give
Make my lord.
succor to this kind of fraud?
No, my lord, kindly appreciate one
Hmm,
thing.
hmm.
We are not, we are not to be blamed for this.
Maybe so. Then you will have a fair chance again.
No, what I find, my.
Yes.
Of course, my lord, speaking very dispassionately. Other than Deepjyoti Sharma, I don't find any, my lord, anything else.
The entire
That's the
result,
only case.
as per the APSC council, the entire list
So my learned friend is.
absolutely justified. He is giving out the actual,
My lord, we are discussing, my lord.
yes.
My lord, I was also on this side for quite long.
Let,
Also,
let,
we also never supported these actions. My lord.
they
That's
can't
why
be,
I'm
just
saying-
can't be.
If I-
Because
my lord,
had
whatever
they
you-
maintained an evaluation sheet, it would have been a different thing. But non-maintenance of evaluation sheet gives rise to any kind of situation. They can do anything.
Oh, my lord.
And then even after having filled in, you see, what is the reason that in the mark sheet, final result sheet, they have filled in the scores and then they do the cuttings? What is the reason? That means that there has been some kind of bargaining.
No, my lord, that we do not
Then
actually
then
know,
one
my
more
lord.
thing,
If
one more
any-
thing, one more thing. What is the date of preparation of this mark sheet?
Lordship 18/9/15.
No, this date of interview. When was it? What is the date
Yes, sir.
mentioned? Where is the signature below the,
No, there is no signature.
no signature? Then who prepared the mark sheet? Even there is no sanctity behind that.
No, in fact, my lord, who was the controller at that point of time, he is presently the chairman. The controller.
In direct equipment, there is no rule of control. Lordship.
Controller has nothing. He is clerical job kind of thing. Present. There are even no signatures on the mark sheets.
No, my lord,
So it was absolutely in the control of the chairman.
My lord, I'll not make this submission
Hmm.
that here is a case lordships can overrule just because I'm making. At the same time, my lord,
there are, my lord, no materials to come to a definite conclusion.
Material is here, Mr. Chaudhary. The mark sheet not having been signed by the chairman, where there is a specific column where the signature is required to be there. If that signature is not there, the entire evaluation process is,
That's why I submitted. I think perhaps if it is some marks case, I'm giving to. Otherwise, my lord.
we can't isolate one.
My lord.
We can't isolate one, sir. The entire process is polluted, tainted, then it has to go in entirety.
And my lord, the petitioner who moved his honorable court, she received the alleged phone call, my lord.
Forget about the phone. Mr. Chaudhary,
16/8/26.
Mr. Chaudhary, forget the phone call for the time being. We are on a larger issue that the record is before us. The fact, which is an admitted practice, that there is an FIR in relation to this fraud also.
Yes.
There is no dispute. The record shows the entire evaluation process is tainted.
That's why the Nana Singh just said, my lord, tomorrow, if the criminal investigation reveals anything, then our appointments can be made subject to the, my lord.
No. Why? At this stage, had you been working, that's a different thing. Then we would perhaps have taken a different view, that it was no fault of yours. But now, since you have not joined the post,
No,
get a fair chance.
No, we have not been allowed to join because of the court's order, my lord, initially.
Yes, that's right. So the situation is catch 22 as it was earlier. Undergo a fresh interview.
No, my lord, my humble submission
You have a
that
chance.
If the materials fall short of that.
Then we will quash the entire recruitment process. Perhaps you will become time barred, age barred, without any scope of age relaxation. So safer option is.
No, I give the lordships, but only submission is, my lord. Perhaps, my lord, there are materials, enough materials are not before lordships.
Enough material, Mr. Chaudhary, now we are telling you the enough material is there. The mark sheet, which was to be signed by the chairman, not having that signature. And the marks allotted by the chairman only, both of the chairpersons, having cuttings with their initials, with no indication on what date it was done. So there is no sanctity in these mark sheets at all. They, so far as the expert is concerned, subject expert, since there are evaluation sheets, his evaluation as such the marks are given, because they didn't have any scope of changing that. There, wherever there was a scope, general bearing, all changes.
In that case, lordship will ask the APSC to prepare a fresh list, my lord, without ignoring those, my lord, over.
Cuttings.
Yes.
But why rely upon the marking pattern of these chairmen? Because the question, when we Mr. Chaudhary, when we interfere, we will have to hold that the non-signing of the mark sheet by the chairperson it creates a great doubt on the marking process. But the only column where the discretion is there is the general bearing part. So on general bearing, let there be a fresh interview by the APSC. Let the candidates face. Let there be a fresh evaluation.
Can the matter come up on Monday, my lord?
Yes, definitely. The Mr. Mazumdar is placed on record. The chart prepared in terms of the order dated so and so. The respondents base for time complete his list on Monday.
Mark sheet, this mark sheet, I have included in the chart and shared with others.
They're a little confidential as
That's
yet.
what I'm saying, man.
Mr. Das, please hand over the mark sheets back to Mr. Moss. The mark sheets annexed with the chart will be kept in a sealed cover. Chart you can give Mr. Mazumdar.
Yes, chart.
We have taken notes.
Yes.
Because the investigation is still on.
They've been seized now, they're part of public domain.
Yes.
They'll be filed along with the chart sheet.
I think state should take note of that aspect. The subject expert has got 20 and the member has 30, it should be reversed. The subject expert should have more marks. Honestly.
There's an ultimate evaluation process, yes.
Yes.
The discretion, knowledge of the subject is more important, basically.
I think, my lord, they should consider amending their position.
Those rules are not before us, Mr.
So I'm just having seen the.
It'll come up in some.
That is the only.
Keeping more than 50%, Ajay has very clear. For interview.
Interview, yes.
That is when they start giving those dusras and doobies.
Lordship, everything is depend upon the mindset of the people. How can I deal with it? If it reverse also, if they are guilty mind people, nothing system would not reverse.
My lord, I can name the chairman, my lord, until Anil Chaudhary and then my lord, one gentleman. Till then, my lord, it was an exceptional public. Then one gentleman came, Dr. P.P. Das. Then this line started.
We'll tell you, in Rajasthan, earlier the selection to judicial services, the interviews were held by the RPSC. One honorable judge used to be the member of the interview board. And when they came back after the interviews, they shared the experiences that both the other members, they were carrying slips with themselves.
This is mine, that is theirs.
You agree on this, we will agree on that. So ultimately, we took the entire process.
Sir, Lordship has indicated this in another litigation. In that Arunachal grade 1 matter.
The entire process now, everything by the High Court. No interference of RPS.
Only, my lord, in 2017, the health department has brought a different bill. So this is not with the APSC now. They have their own board.
But this process will have to be done by the APS.
I'm just pointing.
And now they've
Yes,
tried
yes.
to improve the
They should
things.
do that.
Okay.
Now, my lord, things have improved.
No. The remaining matters, they will have to be
Yes.
spilled over. Now they go in October, sir. Or no more dates in September. We have fixed many matters because every day now hearing matters are, the list is increasing. We are trying to take them up one by one. But more than 7, 8, it's not possible.
Yes.
Can it be that better from 7 to 12?
All in the first week of
12, my
October.
lord, on 12th of September.
First week of October. Already many matters have been fixed up.
Number 2 lots. I missed it.
2, now it goes to October again. October में dates दे देना इनसे. चलिए.